Item number 1 to 70. Item number 80 to 20.
Met previous lordship, my lord. My lord, I beg to mention item number 29, 30 and 31, my lord. With the consent of other side, my lord, filed yesterday one adjournment memo, my lord. On the ground, my lord, this matters I am led by Mr. Senior Counsel, my lord, Jain Sahavla. He is out of station, my lord. Any day lordship will fix this matters.
Then after the summer vacation.
My lord. Obligation, deeply.
Chief, I beg to mention item 27 of today's daily list. This matter, we have filed our wakalatnama yesterday and also a reply to the affidavit filed by the respondents.
Yeah.
So it may be posted after Monday.
Summer vacation.
Obliged, Lord.
May I please, Lordship? I beg to mention for listing one repetition, my lord, on 6th of June, my lord.
I beg to mention a matter for listing, my lord. The matter relates to, my lord, environment rights, my lord.
When?
My lord, maybe on 18th or 19th of June, my lord.
You just.
I'm obliged.
No, please, Your Lordship. My lord, I beg to mention for listing a writ appeal for hearing, my lord.
Hearing.
My lord,
June में लगा था.
kindly oblige, Your Lordship.
Daily list for orders item 1.
May it please your lordship. At the last occasion, accountant general was requested to appeal instruction laws.
Yes. My lord, we have already issued PPO order yesterday. I've given just a copy. Reminder.
Now what remains? Now what remains in this matter?
Lordship, please say permission. Please say this one. Contact president.
We are passing it over timely. You take instructions
Yes,
from
yes,
your
Lordship.
senior.
Yes. Obliged.
Where is Mr. Secretary?
Mr. Secretary. Lordship, he has not reached yet, Lordship.
Ask him.
Yes.
For admission, item 2.
May I please? This is public interest litigation, your lord. Filed by 4 petitioners who are all residents of Silsar town, your lordship. And they're basically aggrieved by your lordship, the action of the municipal board as it then was, your lordship. Now it was converted to municipal corporation, your lordship, to lease out a 19 bighas of land, your lordship, which your lordship is an open space, your lordship, in an area called Gandhi Park, your lordship, in favor of respondent number 10, your lordship. Of your lordship, food court, your lordship, water park, and a star category hotel, your lordship. Essentially, your lordship, we are aggrieved by that, your lordship, and
What is your actual grievance? What do you
Our-
want?
our grievance
So
is
it should be keep like this open space
lordship.
for what?
Lordship, it
What's the
was your
purpose of
lordship, it was in the admittedly what has come out from the pleadings, your lordship. It was your lordship, used for public and semi-public use, your lordship. And it was an open space, one your lordship part was a park.
What actually, how the public were earlier using it?
Lordship, so far as the use is concerned, your lordship, a part of it was a children park, your lordship.
Fine.
And the rest, your lordship, there is a lake, your lordship, Marcy land, your lordship. And your lordship, otherwise it's an open space, your lordship. I have your lordship
But if
narrated
it's an
the,
open space, then certainly the people will misuse it. Either they'll throw garbage in it or something else. What would be the ultimate use?
no, your lordship, there is no, it is not used for your lordship doing garbage, your lordship.
Can't be, you can't stop the people.
If your lordship comes, it's essentially your lordship, man-made ecosystem, your lordship. And it was established, your lordship, in the year 1913, your lordship.
Fine.
By the then, your lordship, under the stewardship of one late Kamini Kumar Chandra, your lordship. And the purpose was to, your lordship, to have the free space, green area to the citizens of Silchar, and as a wetland for your lordship, ground recharging center for maintenance of healthy ecosystem, your lordship. That
Total area of the land is?
29 bighas, your lordship,
29.
total area. 28 bighas, your lordship. Out of his 19 bighas, 9 katha was your lordship sought to be handed over to the respondent number 10, your
Out
lordship.
of it, 9 bighas,
Out of the 19 bighas, your lordship.
19 bighas,
19 kathas, your lordship, and 1 chatak,
almost 20 bighas.
lordship.
More than 65. Yes,
Now, your lordship, so far as the facts are concerned, your lordship, it's like this, your lordship. Now, in 4/2/2017, tender notice was issued, your lordship. And your lordship, on 29/11/2018, Park Committee, your lordship, considered Assam Progressive Developers Limited, that is the respondent number 2, as the, your lordship, most responsive bid, your lordship. Then, your lordship, letter of acceptance was issued on 24/1/2019. And then, your lordship, on 14/3/2019, an agreement was executed, your lordship. In the meanwhile, your lordship,
just a minute. This 4/2/17 tender
tender, your lordship,
and next day,
29/11/2018, your lordship. Respondent numbers bid was considered as the most responsive, and your lordship, it was
respondent number,
respondent number 10, your lordship.
respondent number 10.
9 and 10, your lordship.
9 and 10 bid accepted.
Lordship. And letter of acceptance was issued on 24/1/2019.
Letter of intent or letter of
Letter of acceptance. your lordship.
acceptance.
Then, your lordship, agreement was executed on 14/3/2019.
Yes,
Now, your lordship, after that, your lordship, there are representations submitted at various organizations against this, your lordship. Then, your lordship, inquiry was conducted, your lordship. And that inquiry, your lordship, was conducted by the deputy commissioner, your lordship. 125. The inquiry report, your lordship, was submitted, your lordship. It starts from page 114, your lordship. It's a long report, your lordship.
inquiry report dated
This was dated 12/12/2019, your lordship.
12/12/2019. In page,
Page 114, it starts from page 114, that is the covering letter
fine.
by the additional deputy commissioner who made the inquiry, your lordship. And it starts from 115, your lordship.
Fine.
The aspect, your lordship, that we have raised in the present petition has not been the one of the terms of reference of that inquiry, your lordship. That inquiry, your lordship, there are 3 main scope, your lordship, of the inquiry was, has the municipal board entered into the agreement with Messrs APDL following all the procedures as required? Then whether the agreement was signed with proper authority. Third, analyze the agreement signed to understand whether transfer of property is taking place between municipal board and the development partner, your lordship. And in 125, your lordship, 125, your lordship, the finding is there, your lordship, the conclusion, 125, your lordship, Roman 1, your lordship,
125, yeah.
1, clause 9, your lordship.
Conclusion.
Conclusion. After doing the above analysis and looking at all the documents submitted to the inquiry, this inquiry reaches the following conclusions on the 3 scope as defined above. Number 1, no, the municipal did not enter into agreement with Messrs APDL following all the procedures as required. The agreement was not signed with proper authority by the chairperson Silchar Municipal Board. The agreement signed between municipal board and the development partner Assam Developers Private Limited does not make an arrangement of the nature of transfer of property from the municipal board to the developer. Now, these are the 3 findings, your lordship, of this inquiry, your lordship. Now, your lordship, in the meanwhile, your lordship, one of the ward commissioner, your lordship, he filed a title suit, your lordship. Essentially on your lordship, violation of section 63 and 64 of the Municipal Act, your lordship. এটা আমি কোনটা paragraph করতেছি? 62 and 63. And that, your lordship, title suit, your lordship, no injunction order.
Just a minute.
Lordship. Yes, 21 of it.
Yes,
Lordship. Now, your lordship, in the meanwhile, your lordship, one of the ward
this
commissioner, of-
section 63 and 64, why you are referring for that?
in fact, your lordship, in my petition, your lordship, my basic, your lordship, argument will be on the point of your lordship, environmental aspect, your lordship, and also on your lordship, whether your lordship, they can, your lordship, change the land use pattern, your lordship, without amending the master plan or not, your lordship. And even if they amend it also, whether it is they can, your lordship, the municipal authorities can allow your lordship a open space to be used for your lordship, private profit, your lordship. That will be my argument, your lordship. 63, 64 is also there, your lordship, but before that, your lordship, on a title suit number 56 of 2019 was filed by one Ranjan Roy, your lordship, who was a member at the relevant point of time of Silchar Municipal Board, your lordship, on these grounds, your lordship, and no injunction was granted in his favor, your lordship. That I have, your lordship, stated in my para 21 of my PR petition, your lordship. That's to disclose that there was the issue was brought before a court of law, your lordship,
You are disclosing this fact.
Yes, sir, I am disclosing that fact, Your Lordship, in my petition, Your Lordship. Now, Your Lordship, coming to Your Lordship, this report, Your Lordship, I would like to, Your Lordship, point out only 2 or 3 points here, Your Lordship. In page 117, Your Lordship, there was 3 findings, Your Lordship, before the conclusion. Page 117, Your Lordship.
Yes.
Based on this resolution, the tender notification is given in newspaper on 4/2/2017 after a delay of around 20 months. And the scope of works in the said notification is the upgradation, renovation, operation, maintenance of Gandhi Park. The notification apparently expands the scope of works beyond the scope approved in the board resolution. However, the chairman in his reply, Annexure 9 3.1a clarified that setting up a water park is the upgradation, renovation and existing fellow land of the Gandhi Park, and the operation maintenance is of such upgraded Gandhi Park to avoid lingering of the entire system. That's one, Your Lordship, that there is a finding that they have gone beyond what board resolution is there. That's true. And secondly, Your Lordship,
Let us go through the board resolution.
that is not with me, Your Lordship. I don't have, I have a copy of this. Then, Your Lordship, 118, Your Lordship.
Is there
Page-
any mention about the board resolution in this
Yes, Your Lordship, board resolution, Your Lordship,
page 8 of the resolution?
Lordship. They have, in the report, they have annexed, Your Lordship, as an annexure, but that was not provided to us, Your Lord. Now on 118, Your Lordship,
Just a minute. Yes. Yes,
serial number 6, the point to note here is that board resolved to develop lying vacant space in Gandhi Park by constructing a multi-story buildings, modern parks, etc. in PPP model in only on 28/5/2018. However, the proposal to get this work done was submitted around 15 months prior to this meeting. Also, these proposals were submitted against the notification which required proposal for upgradation, renovation of Gandhi Park by developing only water park in the vacant space as per point 1 above, Your Lordship.
where you are reading?
Lordship, page 118, serial number 6, Your Lordship.
Yes.
The point to note here is that board resolved to develop lying vacant space in Gandhi Park by constructing multi-story buildings, modern parks, etc. in PPP model only on 28/5/2018. However, the proposal to get this work done was submitted around 15 months prior to this meeting, Your Lordship. Also, these proposals were submitted against the notifications which required proposal for upgradation, renovation of the Gandhi Park by developing only water park in the vacant space as per point 1 above. Initially, it was to, Your Lordship, develop a water park only, Your Lordship. Subsequently, Your Lordship, these issues, Your Lordship, these proposals came up, Your Lordship. Then, Your Lordship, on the point which have been raised before the authorities, Your Lordship, regarding environmental degradation, there was a reply by them to that, Your Lordship. And in the resolution dated 18/1/2019, there is a reference to this, Your Lordship. Next, Roman 2, Your Lordship. A figure of 100,000 trees mentioned in the minutes of the meeting on 18/1/2019, but there is no explanation on the basis of which 1,000 trees has been fixed. On asking whether any environmental study has been done to assess the loss to ecology by the project, the chairman has replied that the matter was referred to Messrs. Tentron Engineering Consultancy Private Limited, Kolkata, West Bengal, though through the developer APDL, and as per the advice opinion, the scheme has been taken up. However, no such advice opinion was submitted to the inquiry, Your Lord.
Yes.
These 3 points, Your Lordship, I am relying on, Your Lordship, of the report, Your Lordship. Now, Your Lordship, ultimately, Your Lordship, our case is that, Your Lordship, that even assuming, Your Lordship, this is the, Your Lordship, public and semi-public space, Your Lordship. Ultimately, master plan, Your Lordship, as per the Assam Town and Country Planning and Master Plan is notified, Your Lordship. And master plan in, Your Lordship, Act, your lordship, the Town and Country Planning Act specifically lays down that until and unless there is a change in the land use pattern by notifying in the master plan, they cannot use it, your lordship. Now, your lordship, they said, your lordship, in their affidavit, that in and around that particular area, your lordship, that these lands are, your lordship, commercial lands, your lordship. Commercial has been used for commercial purpose,
In the master plan, this particular land is shown as what?
public and semi-public space, your lordship. Although, your lordship, this is a recreational, your lordship, that has been admitted by both the respondent number 9 and 10 as well as the municipal corporation in their affidavit, your lordship. And while looking at the master plan, your lordship,
Yes,
lordship, while looking at the master plan, your lordship, we will have to also see the objective behind, your lordship, setting up of this man-made ecosystem, your lordship. The purpose, your lordship, as I have stated in my para 9 of my PIL petition, your lordship, is very clear. To cater to the needs of the general public, your lordship, for open space. Now, your lordship knows very well, your lordship, in an urbanized society, your lordship, and Silchar is a town, your lordship, that which is slowly and slowly becoming big and congested, your lordship. The open space is very less, your lordship. In that situation, your lordship, this is a space like this, your lordship. Open space like this has a huge importance for the, your lordship, general public, your lordship. Now, your lordship will kindly come to the affidavit filed by the municipal board, your lordship. There are two affidavits by them, your lordship. In the second affidavit,
What is the date of it?
this was, your lordship, we received it on 8/2/2014 and it was filed on 31st of July, 2013. Affidavit is executed on, lordship. It is page number 292, your lordship, running page.
292.
এখন আমি আমাকে সার্চ করেছে 8/2/2024
No, it's not telling.
lordship.
292 is the, by one of the affidavit in reply by the petitioner.
Lordship. Here, your lordship, it was marked as continuation was, your lordship, 292. It was by the Rajiv Roy, your lordship.
Rajiv Roy.
337. 8th August 2023.
Lordship.
Yes. Additional affidavit.
Lordship, additional affidavit by the municipal corporation board, your lord. Para 3, your lordship.
Yes, sir. Yeah,
Lordship. That the deponent begs to state that the entire Gandhi Park consists of a total area of 28 bighas of land, out of which the existing children park consists of 5 bighas and Bipin Chandrapal ground, Byam Vidyalaya consists of 4 bighas. And Amrut Water Reservoir project consists of another 2 bighas. The children park is mainly used by the people of that area for recreational purposes. The amusement park will be constructed for recreational purposes, playing activities for children and other people, which will be in addition to the existing park. further, the hotel cum banquet hall will be constructed over 1 bigha of land, and the market complex will be constructed over another 1 bigha of land. It is also pertinent to mention that place over which the hotel and the marketplace.
Yeah.
Of another 1 bigha of land, and it is also pertinent to mention that the place over which the hotel and the marketplace will be constructed does not come within the purview of the existing children park, that the same is not being used by anybody, rather the same is a marshy barren land and is not fit for use by the people. Now pausing here for a moment, your lordship. They need 1 bigha for your lordship land for market complex, 1 bigha for your lordship banquet hall, your lordship, and children park is already there. Now, why they have to transfer the entire 19 bighas of land for this purpose, your lordship? On the one hand, you are saying that 1 bigha for this, 1 bigha for this, and the entire 19 bighas of land, why are you then transferring to the developer, your lordship? If that be the case, and it is, your lordship, this is shown from your lordship record. Based on record, this averment, your lordship.
Yes.
And secondly, your lordship, they have admitted that this is a marshy and barren land, your lordship. Now, the marshy land has its own importance, your lordship. Respondent number 9 and 10, your lordship, while filing their first affidavit, has said, claimed it to be a wetland, your lordship. If it is wetland, then your lordship, our case gets strengthened, your lordship. If it is a wetland. Now, your lordship, they then came up with another affidavit. When we replied to that, your lordship, they now say that yes, it is a marshy land, that's why we use the term wetland, even if it is a marshy land.
Marshy land and wetland are the same thing.
Same, your lordship, same, your lordship. Ultimately, the importance of wetland, your lordship, is known to all, your lordship. Now, what is happening in Guwahati city due to, your lordship, encroachment in wetlands, your lordship, we have seen, your lordship. Now, by doing this, your lordship, yes, development is, necessity of development is there, your lordship. Development by way of, your lordship, construction of hotel, food parks. I don't know, your lordship, what kind of development that will cater to the needs of general public. But at the end of the day, your lordship, these open spaces are only, your lordship, breathing spaces for the lungs of a congested city like Silchar, Guwahati, etc. Your lordship. Now, if we, in the name of development, we start, your lordship, occupying those lands, your lordship, open lands, your lordship, then the very objective for which these were set up by those, your lordship, visionaries, your lordship, that will go, your lordship. That's our case, your lordship.
So is there anything in the Wetland Preservation Act which is?
No, your lordship, I have seen, your lordship, that, your lordship, since it is not defined as, declared as a wetland, your lordship, it will not come under that, your lordship. But, your lordship, proposal, your lordship, as has come out from the mouth of Honorable Chief Minister, that they are going to, your lordship, declare many such places as a wetland, your lordship. That, of course, your lordship, right now I don't have that statement, but that's a statement, your lordship, that has. But, your lordship, ultimately, your lordship, if they do so, your lordship, that will be to the peril of the general public interest, your lordship. That's our case. And secondly, your lordship, if had it been the intention of the planners, your lordship, that this will be used for commercial purpose, they would not have, your lordship, make it public and semi-public zone, your
What
lordship.
is semi-public?
Your lordship, that has been defined, your lordship, in the regulation, the master plan itself, your lordship. In the Town and Country Planning Act also, and here also it is defined, your lordship. I have annexed, that's page 127, your lordship. And relevant page is page 131. 131.
Annexure 15.
Lordship, Annexure 15, your lordship. It starts from
Yes.
page 131, your lordship. Public and semi-public place means any place or building which is open for use and enjoyment of public, whether it is actually used or enjoyed by the public or not, and whether the entry is regulated by any charge or not, your lordship.
Public.
And commercial use is, your lordship, defined in page 129, your lordship.
Yes.
Commercial use includes the use of any land or building or part thereof for the purpose of commerce as an office, whether attached to industry or otherwise, your lordship.
Yes.
Therefore, when, your lordship, the land use pattern is, your lordship, is clearly mentioned, your lordship, we are going for a commercial purpose.
Yes.
And in Town and Country Planning Act, your lordship,
So Mr. Botago, show us how this land is public and semi-public category land.
lordship, they have admitted it, your lordship. The Silchar municipal
Apart from that, is there anything in the master plan zoning?
master plan, they have annexed, your lordship, but since they have admitted it, your lordship, in the master plan itself, it was reflected that, your lordship, it is a public and semi-public place, your lordship. That is an admitted position, your lordship. In fact, your lordship, in my petition, your lordship, I have wrongly termed it as a green belt, your lordship, but they have clarified it, and I am advancing my argument, accepting that this is a public and semi-public land, your lordship. Section 11 of the Town and Country Planning Act, your lordship. What did you say? No. Section 11, may I read, your lordship? May I read? The master plan to be prepared as defined under section 9 may include a general land use plan for residential, commercial, industrial, recreational, and public and semi-public purpose, your lordship. That means, your lordship, the land use pattern for commercial cannot be equated with the semi-public and public, your lordship. Therefore, your lordship, separate heading for commercial, semi-public, public, recreational, industrial, all, your lordship. Now then B, your lordship, zoning plan, then rest we don't require, your lordship. Then your lordship may kindly come to section 14. The state government may review the plan and may modify the plan and the zoning regulation from time to time in such manner and in such procedure as followed for the preparation and approval of the original plan and the regulations. That means until and unless that is your
It is an admitted position that
lordship,
the master plan has not been reviewed or amended.
lordship, lordship. Now therefore, in my humble submission, your lordship, the present action of the authority goes against their own master plan. Without modifying, they could not have done it. Even if they would have modified, then also it would have been illegal, your lordship, on their part. That to your lordship to convert a open space.
That is altogether different thing. If they
Lordship.
not,
Lordship.
then this question will not come.
Lordship, lordship, lordship. That's your
Who
lordship.
had initiated this inquiry conducted by the district administration?
It is by the, your lordship, by the additional deputy commissioner. Your lordship will kindly
Who
come.
has ordered the inquiry, Mr.?
It is by the director, you know. I
By
have
the
come.
government or
Your lordship will kindly come to page 114.
Yeah.
It is says, your lordship, enquiry report on development and so and so, letter number so and so issued from the director of municipal administration, Guwahati. On the basis of a letter, your lordship, forwarded by the director of municipal administration, your lordship. A memorandum was forwarded by the director of municipal administration Dispur by this letter under reference to your honor. Your honor and endorsed that letter to the undersigned, directing the undersigned to conduct an inquiry and submit a report, your lordship.
So, has the government filed any affidavit?
Government has not filed any affidavit, your lordship.
why? What's your stand? What's this? Started arguing and
You initiate an inquiry, the inquiry report does not support the action of the municipal authority, and you remain silent. You are not able to tell the court also what is your stand. And you are saying this after the matter was heard for half an hour. What is the government has accepted the report? That is the result. What action this man has taken, the director? Mr. Datta, who is the chairman of the municipal board?
Now it's run by executive officer, Melu. There is no board now.
There is no board.
It is now your lordship a corporation, your lordship.
No, it's yet to be corporation. Now it's still it's a board. My lord, the stand of the government, if your lordship like to see, at page 126, which is the stand of the government,
126.
126.
Is there any affidavit by the government?
No,
No, in my petition itself, one or letter is there.
One twenty-six.
Six.
What is it?
It's from, my lord, joint secretary to the executive officer, Silchar Municipal Board. With reference to the subject cited above, I am directed to state that as per the decision taken in the meeting held on so and so, the executive officer, Silchar Municipal Board, will enter into all agreement with APDL, that is respond number 9 and 10, following all due procedures as observed by the then Deputy Commissioner Kachhad in the matter relating to development of Gandhi Park Park, wide letter number so and so. Silchar Municipal Board will ensure that no transfer of land of municipal board at any cost is to be made by the developer without approval of the government. Any dispute of the title of land of Gandhi Park will be referred to the Revenue Department through the Administrative Department, that is Urban Development Department. Further, Silchar Municipal Board will comply with the final outcome of the Honorable Court's order verdict in all the matters relating to development of Gandhi Park. It was decided that all work of development of Gandhi Park Silchar is to be resumed with immediate effect. That means it is the ratification of all the.
What is the purpose in giving such direction when the agreement was already executed in the year 2019?
Yes, my lord,
Now they are giving this direction in January 2021 when everything is over.
possibly is
What
a
is
kind
this
of.
stand and what about the report of this additional commissioner?
My lord,
How they responded to it?
maybe, my lord, because the department is to ratify the activities of the board.
Rectify the,
Ratification of the,
sir, how
whatever-
can it be question of ratification, sir? They have said enter into a new agreement. What is this?
that should have been much earlier than that, my lord.
Actually, before that,
Yes,
what is the use of this?
but they possibly they construed that.
And this is self-contradictory. This is self-contradictory. On one hand says no transfer of land, await verdict of the court. And then it says carry on with the work. What is the meaning of this? It is not. Has the work started?
No, your lordship.
No, it's an
Work has not
old
started.
method. But only thing, there is no transfer of land, my lord. Is a
That
lease for
means
3 years.
That we will see, sir.
Lease is a transfer of interest.
That to some extent is there, obviously, because the 3 years lease is there. And then subject to, my lord, so long they will continue, there will be 10% enhancement. Those conditions are placed here.
As good as.
You are appearing for?
I'm waiting for the developer, point number 9 and 10.
No, sir, what is this? This commissioner, additional commissioner report says the agreement signed between the municipal board so and so, does make an arrangement on nature of transfer of property. This is what the report is.
That is wrong. The agreement itself is before your lordship.
That is wrong, but ultimately, after interpreting that agreement, this is what the additional commissioner's report is. Maybe rightly, wrongly, whatever it may be. What is the response of the state government to that, sir?
But I may just point out, lordship, we were not allowed, we were invited to participate in the inquiry.
Participate in the
Inquiry. So now behind that.
inquiry, in fact, you are the beneficiary. Certainly, you are not supposed to. How the things are proceeded, that was the matter of inquiry. And ultimately, he submitted a report. What happened to that report? You can't keep this report in the dustbin, sir. That is for the state government. This is absolutely, if you are, this petition is going on since 2021 and still after around 3 years, no response by this state. It's too much. Ultimately, it's a project is, even though if it is in benefit of the public at large, why to delay on the part of the government for that?
We have so reasons. If it's imagine, here is the whole issue, what is the land about, they have, what photographs are there.
But then we will hear you. Without hearing you, we are not going to pass any orders, sir.
Yeah.
But ultimately, at least what is the response to the, what is the stand of the government? Whether they are supporting it, not supporting it, whatever it may be, we will consider it. It may not be influenced by the whatever the stand of the state government. Ultimately, we have to take a decision in accordance with law. File your reply. What time, by what time you will file reply? And take into consideration everything, the additional affidavits, further affidavits, whatever they have filed, come with a clear stand.
So far, the report of the ADC, the lordship will give an independent look into the matter because he has said certain things, my lord, is not in terms of the law. So he said that the agreement is in perpetuity. How it can be, my lord? When the terms is very
Mr.
clearly
Datta,
given 3
where
years.
is the file? Where is the relevant file of the municipal board which processed this entire?
That your
I would
lordship
like to
will
see
like
the
to see.
records.
Yes, yes,
Yes,
I'll
please, please,
produce.
please.
Okay. This petition is filed by the petitioners in public interest, raising a concern about the agreement entered into, the agreement executed between the Silchar Municipal Board and the respondent number 8 and 9 for the purpose of development of the Gandhi Park situated in the middle of the Silchar town. The petitioners are relying on a report submitted by the additional commissioner, additional deputy commissioner or additional commissioner?
Additional, at relevant point of time, additional deputy commissioner. Now,
The additional commissioner now, deputy commissioner, Silchar, wherein certain observations are made. Full stop. Affidavits and counter affidavits have been filed by the municipal board, a municipal corporation, Silchar
Municipal board,
Municipal Board. Still it is municipal board.
still it's board.
By the petitioner, Silchar Municipal Board, as well as the private respondents. However, no response on behalf of the state is filed till date. Full stop. We are of the view that for the proper adjudication of the controversy involved in this petition, the state has to clarify its stand. Hence, the council so and so for state is directed to file an affidavit on behalf of the state clarifying its stand on the point involved within a period of
1 week.
you'll be able to file reply within a week. You have to clarify your stand. 19th June. 19th of June, before the green bench. Before the green bench.
This is the 19th of June, we will do. Let us do.
Next green bench, probably consider
Thursday.
Thursday. 20th of June. 20th of June. Before the green bench.
My lord, further line may be added to produce the record by the municipal board.
The concept of the municipal board is also directed to produce the record wherein a record regarding the decision taken by the municipal board, Silchar, regarding the municipal board Silchar for establishing an amusement park.
Yes.
Lordship, may I point
What
out,
is part in question?
point out one aspect, Your Lordship. By order dated 25/7/2022, this honorable court was pleased to direct us to increase Silchar Development Authority as one of the respondents, Your Lordship.
You've done it already. You've done it already.
We have done, Your Lordship, but they have also not filed their affidavit. That's what I wanted.
But since the agreement is by the municipal board, lots.
District commission.
Deeply obliged.
File the affidavit at least 4 days prior to the next day. So that it is
With this understanding, you file the at least 3-4 days, 5 days prior, so they may file their counter, whatever if they require.
Deeply obliged.
For hearing, item 3 to 17.
May I please, your Lordship, I have verified, Lordship, item number 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, and 17. Lordship, in all these matters, Lordship, the appellate authority has already passed its order. And Lordship, therefore, Lordship, this matter may be disposed of in that line. Because the appellate authority has already passed its order. So
So they only in item number 3 and 16.
3 and 16 it is left.
16, Your Lordship. Lordship, item number 16, we have not been able to contact with the petitioner, Your Lordship.
But since it's a matter of 2018, if other appeals have already been decided, this.
Yes,
matter
Lordship,
already
may
been
dispose of the
decided.
matter in the similar view, Lordship.
And this, then all the matters, in all the matters, it has been done.
Except 3.
3 is different.
Three is something.
Item 3 is different.
3 is different, 3 is different, yes. So, look here, item number 4 to 17. Learn it. Concept of the petitioners have submitted that since the appellate authority has already quashed कर दिया आपका assessment order?
Lordship, disposed of the matters.
Has already disposed of,
The appeals.
has already passed final order in respect of the assessment. In respect of the assessment years in question, these matters have become infectious, dismissed as infectious.
Lordship, may kindly write disposed of because in view of the interim order, my only submission.
Yeah,
Disposed of.
infectious means infectious, once they have decided, your whatever the fake.
Disposed of, Lordship, may kindly write disposed of.
Matters are closed according, it's, they decide so and so, the revision petitions are closed accordingly.
Much obliged. Much obliged. Much obliged.
Otherwise, there is nothing.
Otherwise, Lordship, we'll file matters again, Lordship, regarding this issue. Then what
Why?
will happen? The respondents will come up with the plea that it has been dismissed. So, Lordship, it should not be like that. It is not like that. I have not.
Dismissed as infectious means something, it's okay. we are-
And last but not the least, it may have some difference in the material instruction also.
Much obliged, Lordship. I am obliged, Lordship.
Yes,
Item 3.
May it please, Lordship. Lordship, my lord. In the present petition, my lord, the issue involved is that, my lord, whether
last occasion, we asked you to produce some case law on this.
I have found one, my lord. Same as issue.
Which relevant para is?
Well, the question that is framed with para 3, my lord. The question that is framed, my lord.
Para 3,
Para 3 is the question framed, my lord.
yes.
Now the question now been examined here is to whether the present appeal would be governed by the Consumer Protection Act 2019 or under the erstwhile 1986 Act, my lord.
Yeah.
My lord, in para 4, my lord, difference is there, my lord.
Yeah.
In the earlier act, my lord, there was a requirement to deposit either 50%,
Read,
my lord.
relevant.
In terms of section 67 of the 2019 Act, no appeal against the order of National Commission shall be entertained by the Supreme Court unless the person has deposited 50% of the amount required to be paid. Whereas under the 1986 Act, by virtue of a proviso inserted by Central Act 62 of 2002, with effect from 15/3/2003, the condition was that no appeal shall be entertained by the Supreme Court unless the person who is required to pay the amount deposit 50% of the amount or 50,000, whichever is less, my lord.
Yes,
My lord, here the judgment was passed under the old act, my lord. And all that after coming into effect of the new act, my lord, the new act coming into effect, my lord, on 27/2020, and the judgment was passed on 27/1/2021, my lord. Then the issue will,
they came into force in 2020.
my lord,
This provision regarding deposit of 50%.
my lord, it is stated in paragraph 5, my lord.
Yes, learned Attorney General appearing on behalf of the appeal preferred under section 2 that came into force. So it's still like.
My judgment
So
was
the order under challenge was of the year
2001, my lord. It is in paragraph 2, my lord. Last line, the said complaint was allowed on 27/1/2021.
No. Thereafter, this tribunal has passed the order. National Commission by filing the complaint, the said complaint was allowed on, appellant rejected the insurance claim of the. Later the complaint was-
Where is the finding of the court?
My lord, paragraph 34 is the finding, my last paragraph.
34.
34. After discussing all the judgment court. Last paragraph, my lord.
in view of the binding precedent of the constitutional bench, judgment referred to the hold that the onerous condition of amount awarded will not be applicable when filed prior to the so and so, therefore the IA is allowed. Yes.
Lordship, Lordship, if Lordship may kindly take up the VAT.
VAT?
VAT book, Lordship.
Yeah, that, yeah.
Lordship, there is section 109, which provides for the transitional provision. And under the transitional provision, if particularly 2B and F, Lordship.
109.
Particular 2B and F, Lordship.
Just the next one. It's two,
2B, Lordship.
B,
B.
B. Any dealer liable to furnish return on the repeal act immediately before shall furnish the return in respect of the tax payable for sales. But they immediately before such a point, they in accordance with the repeal act. All the proceeding assessment, I mean, legal period passed. Yes, another
Another 2F, Lordship.
F.
In case of
So you, that supports his case.
yes, in that sense, Lordship, it's supposed, but the date of the order, assessment order, Lordship, it appears from the page 22 annexed
That is of 2006.
2006, Lordship. In that situation, Lordship, VAT will, the provisions of VAT in case of the appeal filed by him, that will apply, and he has to deposit the 25%, Lordship, for consent.
Whatever this 25% he is not supposed to pay because the assessment relates to the year 2002 and 3,
2 and 3. Yes, ma'am.
Ultimately, the assessment order was passed in the year 2006.
6.
In between this 2005 act came,
Yes.
but pursuant to this, in view of the judgment passed by the learned single judge, where they said every complaint filed in this Supreme Court, every complaint filed prior to this amendment would be governed
to
by
be
the old
considered.
act.
Yeah.
So here also the assessment is of assessment of this assessment here is prior to 2005. That has to be governed. Applying this analogy.
Yes, Lordship may apply. I have seen that, judgment, Lordship. And then, in that case, Lordship will have to, remand back.
Goes for all this.
Oblige, your lordship.
Pass over meter 1.
Lordship, due to some personal difficulty, my senior could not come, Lordship, but I have taken the instruction from the client. This matter may be closed now.
Okay. Okay. This writ appeal is filed by the appellant being agreed with the order. This writ appeal is filed by the appellant being agreed with the order dated 2/11/2022, passed by the learned single judge in WPC number 6887/2022, whereby the claim of the petitioner to grant her benefit in the benefit, pensionary benefit treating her as revenue Shrestidar has been rejected. Stop. During the pendency of the present appeal, the state has considered the case of the appellant and has decided to grant pensionary benefit to the appellant, treating her as a revenue Shrestidar. Full stop. Learned counsel appearing for the Accountant General Department has submitted that wide order dated 29/5/2024, the Accountant General, the Principal Accountant General Assam has already issued a letter to the Treasury Officer Nagaon to grant the benefit of the pension treating the petitioner, treating the appellant as revenue Shrestidar as per the PPO issued, as per the PPO attached, as per the PPO issued by the Office of the Accountant, Principal Accountant General. Full stop. The copy of the letter of this effect dated 29/5/2024 is produced on record, which is taken on, is produced, which is taken on record. Learned counsel appearing for the appellant has also submitted that since the relief as prayed for in the writ petition has already been granted to the appellant, this writ appeal has become infructuous. It's stopped. Taking into consideration the above facts and circumstances of the case, we are of the view that since the claim of the appellant to grant her pensionary benefits as revenue, while treating her as revenue Shishtidar has already been granted, this writ appeal as well as the writ petition. This writ appeal is allowed. The improved order passed by the learned single judge in writ petition number is set aside.
Obliged.
Like one.
For hearing, item 18 to 21.
This cases in item number 20, 20, 18, 20 and 21, affidavit was filed when they were yesterday.
Affidavit.
Yes, by the appellant. 20, 21 by the same appellant, but 18 is different appellant. I've sent it to my client. They said they will like to file a reply to this. Maybe after your lordship take up.
We have heard affidavit
My
yesterday
lord,
only.
my lord, what we would like to submit is, I think we'll have to challenge it before the single judgment. Pursuant to your lordship's order, they have rejected our representations. So naturally, my lord, a new cause of action has arisen. Only thing is, my lord, while disposing the representation, the learned single judge will not take note of the judgment under it.
So that the lordship will consider. Let me file an counter reply to this. Because they have
When this court has directed you to file an affidavit or representation of.
Yes, my lord. The order. It is what? Page 25/8/23 was the order of this honorable court.
25.
25/8/23. 25th of August, 23. During the course of submission, has a lawsuit. So representative appellant has drawn attention of this court to two communications dated so and so, issued by area manager FCI and executive director FCI respectively, and asked that the FCI official themselves realize that there was a sudden change in this scenario as per the Supreme Court's direction, due to which the earlier practice of allowing load of trucks carrying food grain to the extent of 22 MT was mandatorily curtailed to 9 MT only. The FCI authorities wrote to the state government seeking relaxation exemption from this embargo to the trucks of FCI. The Chaudhary has asked that in view of the sudden change of scenario, whereby loading capacity of the trucks are required to be reduced to almost less than 50%, the price offered by the appellant herein became unworkable. Thus, an exercise to work out the rate was required to be undertaken in accordance with clause 26.6 of the Storage and Contract Manual of FCI. He does praise that the appellant herein may be permitted to make representation to the appropriate authority of the FCI in above terms, and such representation may be considered objectively. So, my lord, this was the plan.
Langan single judge has considered everything, all this aspect and pass the judgment. Lordship. The lordship will then.
Mr. What is the objection in that?
My lord, this aspect, the order passed by your lordship based on the.
Sir, the two communications dated 7/6/2000 10 and 8/6/2010.
This was dealt with by the Honorable Skill Judge in extension.
That has been-
In the judgment. Therefore, my lord, lordship will, either then lordship will hear the appeal, my lord, then. Hear the appeal.
We are
Not-
simply saying that the learned single judge on its own merits, that's all.
No,
Will
my lord,
say that if fresh repetition is filed, the learned single judge will decide the same in.
my
on
lord,
its own merits.
lordship will then look into those communications. And then if a lordship feels that, my lord, because the lordship will look into those communications, my lord, two communications, then lordship will therefore.
Mr. Roy, he wants to withdraw to pursue.
Withdraw-
Why, how can you stop?
Withdraw, I have no objection.
But you want that next writ petition will be governed by the earlier order.
No, what I'm saying, if.
Is this a reasonable stand? If he wants to challenge orders, he will do it on his own merit. Otherwise, his case will be pre-decided by the earlier judgments.
Then what is the point in granting him a liberty?
My lord, liberty.
Since they have filed a representation pursuant to the direction given by this court on 25/8/2023, and those representations are now been decided. Now they want to challenge that whatever the order, what's wrong in that?
I have no objection on that. My lord, my submission is, if the writ petition is filed only on the communications, two communications and the order passed, but I have no objection. But once it has gone into, in this writ petition, has gone into various other aspects, because
That is why.
after acceptance of the bid, they said my lord, did not submit the security, therefore EMD was forfeited.
Again, the learned single judge will consider all those available, whatever the arguments are there, sir.
A fresh, my lord, lordship will, if lordship opens the matter of hearing the entire matter afresh.
Sir, again,
Because
if they raise this, and then the learned single judge can very well say that this point was earlier raised and decided, I'm not going to look into all this. What is the problem in that? Own merits?
on its own merits.
On in own merits. Yes. Okay. When it concept of the applicant has submitted that pursuant to the liberty granted by this court. Wide order dated 25/8/2023. The appellants have moved their representation before the chief managing director FCI, who in turn has decided those representations afresh. It is some council has submitted that submitted on instructions that the appellants wants to
Order to 21.
challenge the said decision of the chief managing director FCI passed on their representations filed in accordance with the liberty granted by this court on 25/8/2023 before the learned single judge. So they want to withdraw so the appellants wants to withdraw these appeals with liberty to file fresh writ petition. Would stop. Dismiss with liberty as prayed for. Needless to say that the learned, if any such writ petitions are filed, filed on behalf of the appellants, the learned single judge shall consider those writ petitions on their own merit.
Lordship, kindly mention the date, madam. It's 21/12/23. That order of the authority which now will be challenged.
Chief Managing Director 21 decided on representation by the order 21/12/2020.
It should be chairman come managing director, not chief managing director.
Chairman come managing director.
Chairman come Managing Director.
So this dispose of item numbers,
Item 18 to 21. 21 to 9.
21. 18 to 21.
18 to 21.
18 to 21. 18 to
18 to 21.
Yours also same.
For item 18, Lord. Item 18.
18 to 21.
Yes,
ठीक है, ठीक है. अलग अलग कैसे?
Your नाम पे कितना है? 18.
हमारा तो 21.
18 of the नाम बोल दीजिए.
Well, I think in my learned friend's case, the order is 20/12. In our case, it is 21/12.
The representation was disposed of by order dated 20/12/2023.
In his case,
20th of December.
Yes, ma'am.
one day ahead.
one day ahead and you're 21st. Respectively,
Nominated.
21st of February and this 20th of December and 21st of respective.
Item 22.
In this case, Lordship, I am prepared to do the case, but I am feeling little bit unwell because of my voices also. So could it be taken on Monday, Lordship?
Then in next week, if there is no urgency, we'll fix it after summer vacation.
Yes, Lord.
Yes, Mr. Summer
After vacation, my lord.
Summer vacation. Summer vacation.
In fact, I am fully prepared, but I will not be able to argue today because of my voice is totally down.
Medicine वगैरह कोई लिया नहीं आपने?
लिया।
लिया।
The medicine which he said, I am not taking it.
If he's
Always giving
offering,
wrong
even
advice.
though if he's offering,
Always giving wrong advice.
even though if he's offering,
He will not offer, Lordship. He has a chosen person whom he offers.
But
I
Mr.
have the
Speaker,
list.
sometimes wrong advices are given for the right reason also. That you agree.
But I have to get rest someday. He's a neighbor, friendly neighbor of mine, but
okay.
Welcome anytime, madam. Yes, midnight also.
Yes, next.
deeply.
Item 23.
My lord, I have submitted my compilation.
May it please your lordship. My lord, my lord, writ appeal is against the impugned order, my lord, passed dated 22/7/2020, passed by the learned single judge. Your lordship will find it, page 141. And the relevant portions, your lordship will find, my lord, at page 148, para 26. For the reasons above, this court found that the B.Ed degree certificate of the respondent number 7, that is the appellant, your lordship, dated 8/3/1997, issued by the Assam University, that was issued after the appointed day 17/8/1995. Now, appointed day, your lordship will find, my lord, from page 30, that it is 1/7/1995, your lordship. Is not a valid degree, your lordship. And the reasonings for that order, your lordship will find at page 22 and 24, your lordship. Paragraph of this, my lord, page 148, paragraph 22 and 24, your lordship. Now, the contention, my lord, of the writ petitioner is that, my lord, that this Vivekananda Institution of Education, my lord, it was recognized by the NCTE on 13/3/2021. Whereas that, my lord, the appellant, respondent number 7 in the writ petition, my lord, he passed the B.Ed examination, my lord, during the year 1996 as a student of the session 1995-96. And, my lord, the certificate was issued to him on 3/8/1997. And as such, the certificate is not valid, your lord. That is the contention, your lord. Paragraph 22 and 24, your lord, of page 148. Now, my lord, I will take your lordship to page 29, your lord. When the petitioner was admitted, your lordship, you will find, my lord, at page 29. He was admitted into that particular, my lord, institution, Vivekananda College of Education, Karimganj, on 22/6/1995, prior to, my lord, 1/7/95, when the act came into being, your lordship. So the institution was there, continuing the course, your lordship, prior to 1/7/1995. And if that be so, my lord, 6 months' times is, my lord, granted to the, my lord, institution for, my lord, filing their application, your lordship, that is under section 14 of this particular NCT Act, your lordship. Now, page 30, my lord, your lordship will find that this particular act, my lord, came into being on 1st July 1996. Now, another, my lord, now my lord, if 6 months time is allowed to the institution who is, my lord, running its, my lord, courses for B.Ed, then, my lord, firstly, six months time is available to them for continuing the course, your lordship. Then another 6 months time was taken by the NCT, my lord, to issue the, my lord, regulation, your lordship, as to how to apply for recognition, etc. My lord, that observation is there in your lordship's order, your lordship, in the case of Musubbirali, your lordship. Now, my lord, in the meantime, my lord, the Assam University, the institution was affiliated to the Assam University, and Assam University, my lord, granted the permission dated, my lord, 25/7/1995, your lordship, to, my lord, conduct the, my lord, classes, and permission was valid for 1 year, your lordship will find, my lord. Then, my lord, your lordship will find, my lord, that the college, my lord, in the meantime, my lord, had applied for recognition, my lord, on 15/8/1996. 6 months and 6 months, my lord, it was available to the, my lord, institution under the law. And, my lord, by this letter, 12/6/1996, as page 33, your lordship, time was extended to that particular institution to apply for the recognition, your lordship. And in the meantime, when the, my lord, application was pending before the NCT authority, my lord, the present appellant, my lord, respondent number 7, my lord, he was issued with the certificate by the Assam University on, my lord, 8th of March 1997. At that time, the application filed by the institution, my lord, was pending before the, my lord, NCT authority, your lordship. Then your lordship will also find, my lord, page 35, 31st May of 1997, affiliation committee, my lord, had granted the permission, my lord. Your lordship will find page 36 for renewal of permission, my lord.
You have got a degree in 96. You have taken a degree in 97 certificate. But was that here 96? Is it? One more judgment, I think so, of division bench on this point in issue.
My lord, your judgment was passed by the Honorable Court Musubbirali versus State of Assam. My lord, I have submitted it in the case record.
I think so. Another judgment is also.
I have
there.
given in the
Most
compilation.
probably, my lord, in the
All
case
the
record, it is
judgments
there.
No, on the, in terms of Musubbirali,
I have
one
given
judgment is there.
3 judgments I have annexed, my lord, in the compilation. I will place, my lord.
Yeah.
Now, my lord, page 35, your lordship will find that provisional recognition was, my lord, granted to that particular institution, my lord, on 23/6/1990. And accordingly, my lord, it is not a fact that this institution was granted recognition on 13/3/2021.
This institution was very much in existence when this NCT Act came into operation. You moved an application within 6 months.
Yes,
Your application was
pending,
and ultimately recognition was granted in the year 2001.
yes. 2000, not in 2001, 1998, it was granted for the first time. They are saying it is 13/3,
Okay, 1998.
1998.
In between, this BA degree was given to you in the year 1997. Now they are saying that this BA degree was issued to you prior to the date of recognition. Therefore, it is not recognized. It
Exactly.
can't be treated as recognized. In Musaffar Ali, we have taken a view that if the degree was granted later on, but in between the institution was in existence and offering the degrees, it would relate back and all the degrees would be treated as recognized. This is what we have.
Now, my lord, to clarify the matter, my lord, I have submitted a notification issued by the government of India modifying, my lord, or amending this particular act, your lordship. That is also there. And my lord, your lordship will find, my lord, from my lord, page 43, your lordship. Amended permissions, your lordship will find.
40?
Page 43, your lordship. A notification, your lordship will find at page 41. And that was totally ignored, your lordship. Page 41, 43, your lordship may see, my lord, subsection 4 of section 18, your lordship.
Yes.
An order granting recognition to an institution on its application under subsection 2 shall be deemed to be effective from the date of grant of affiliation to it or holding of the examination for a course or training conducted by it for the first time, whichever is earlier. Now, your lordship may kindly see page 31. And in 31, your lordship will see, my lord, my lord, permission or
Order, you are referring to clause 4, na? Order granting recognition to on its application of the shall be deemed to be effective from the date of.
4, my lord. Subsection 4. At page 43, your lord, an order granting recognition. Have your lordship got it, my lord?
Page 43, clause 4.
Yes. My lord, not my lord, section 18B, page 42, my lord, below section 18B. And then, my lord, page 43, subsection 4, your lord. Now, this affiliation or permission, your lordship will find, my lord, from page 31. It was granted on 25/7/1995 by the university concerned, your lord. So, prior to my lord, the issuing of certificate or passing of the examination, my lord, by the appellant respondent number C in the year 1996, your lordship. If you pass the examination in 1996, so as per this particular provisions, my lord, this particular institution is deemed to have been recognized with effect from 25/7/1995 prior to the passing of the examination by the my lord present, my lord, the appellant respondent number 7. Now, your lordship, for judgment of the Supreme Court clarified the matter, my lord. In the case of my lord Bhupendranath Tripathi and my lord, thus in Union of India, including the NECT, your lordship will find their judgment at page 128, your lordship. And your lordship may kindly turn to my lord page 135. 128, your lordship, their judgment. And my lord, your lordship can keep and come to my lord page 135, paragraph 19, your lord.
Yes.
May I read, your lord? A plain reading of provisions suggested that all such institutions offering a course or training in teacher education prior to the act coming into force. My lord, we are conducting the classes since prior to the coming into force of this act, this particular institution, my lord, are entitled to continue such course or training until the application is disposed of, provided such an application has been made within 6 months from appointed date. The consequence.
Yes, we have already understood that matter. Yes, what do you want to say?
I have submitted two compilations.
Yeah, compilation. Sure.
What is the point? First, tell us.
Yes,
This is covered by the previous judgment.
I will submit, my lord. The question is that whether the college concerned is in existence on the day of appointed, my lord, of the NCT, 17/8/1995. That is the crux, my lord. And therefore, I take your lordship to my compilation. My lord, your lordship will find in I've given the list of date. List of date, my learned friend's client has taken admission on 22/6. The university has come into force, my lord, 15/1/1994 pursuant to the Assam University Act 1989. And my lord, my learned friend's client has taken admission on 22/6/1995.
Fine.
The University Act and the statute provides certain guidelines for granting affiliation to the college. Let me take your lordship to that, my lord. Prior to that, section 16 of the NCT Act is very much clear. After 17/8/1995, for offering a degree, one college must be, first it has to be recognized by the NCT, then the question of affiliation will come from the concerned university. That is settled. Now, my lord, whether the college was getting the affiliation prior to that, that is the question. My learned friend has referred to the letter dated 25/7/1995. That letter states that the college is permitted to start the college. Now I'm taking your lordship to the provisions for granting the affiliation. Page 25, lordship, of the compilation. The inspection commission. The inspection commission may take.
So ultimately, the affiliation was granted when?
Not granted. It was granted. It was granted subsequently.
Subsequently, which date?
Date, my lord. It was 23/6/1998, my lord. Provisional permission granted for academic session 1998-1999. I take your lordship, my lord, to the granting of affiliation process.
When?
It was 1998.
1998. Okay, and the appointed day was
7.
And the appointed date was extended up to what?
No, my lord. Extended, my lord. These
Extended up to what?
extended, my lord, 18/8/1998, I think, my lord.
Extended up to 31st of
18/8/1997.
1999.
Benefit
The
of extension.
NCT has extended
My
the
lord, let
appointed
me-
date up to 31st of March 1999.
Yes, yes.
Before that affiliation
That I am
was
not,
there.
that I am not disputing, my lord. That
Then-
I am not at all disputing.
Then-
The question is whether the benefit of extension will go to those institutions which were in existence prior to 17/8/1995. The question is whether this college
this
was.
institution was
No,
very much
not in
institution.
existence, not in existence. That is my submission, my lord.
That is
Because
there.
for,
You yourself
for,
has said that
for
the
coming
university
into
was
existence,
established
let
in
me-
the
let-
year 1994.
let me finish, my lord. For coming into existence, one must have legal existence, not the physical existence like the establishment of building. One must have legal existence means, my lord, it has to be affiliated. It has to be permitted and affiliated by the university concerned prior to 17/8/1995. And for the purpose of granting affiliation, my lord, there is a process in the statute of the university which says, my lord, I'm taking your lordship to the page 47.
Yes.
Page 25 of the
Yes.
compilation, which state there's some process. First process, my lord, on receipt of the permission to start a new college or a college already in existence, the sponsoring body shall constitute a governing body and proceed to make appointment for the post of principal and other academic staff. Here, this letter was issued on 25/7, meaning thereby it has given the permission that you appoint the principal and constitute the governing body, not to start the college. Question of granting affiliation far away. Then I take your lordship the page 26.
Yes.
Establishment of a new college.
Yes.
When it is proposed to establish a new college, the sponsoring body, or in the case of a government college, the head of the department concerned shall submit an application to the registrar in the prescribed form, not later than August 15 of the preceding year, that means previous year, in which it has been intended to start the college, which should be accompanied by a project report giving details as laid down in the regulations. The college, for the purpose of this ordinance, will be the categories of degree colleges, medical colleges, engineering colleges, law colleges, and B.Ed colleges. The privileges of admission to the university for each category shall be decided separately. Initial screening of the application. Then comes the letter of starting the college, then comes the application, then comes the screening. On the receipt of the application along with the prescribed fees, the affiliation committee of the academic council shall scrutinize the application and if necessary, ask for any further clarification from the sponsoring body. And on receipt of such clarification, the committee shall offer its recommendations to the academic council as to whether it is satisfied with the project report and whether there is sufficient ground for starting the college. Then I take your lordship to the provisional affiliation.
There is no need for that. You just give the dates.
Yes, I'm giving my lord.
Give the dates.
Your
We'll
lordship
go
kindly,
through that. Give the dates.
no, my lord, your lordship kindly bear with me.
You give the dates.
I'm giving my lord.
Please give
I
the dates.
I have given
No,
that.
We'll go through that provisions. Please, since you have given us the compilation, give the dates.
Dates are there in the compilation
Give the
itself.
dates. What is your exact objection?
Exact objection is that on the day of coming into force 17/8/1995, the
Yeah.
college was not in existence because, my lord, the college was not having the affiliation from the university. The
Okay.
affiliation, your lordship, what meant, my lord, the 25/7/1995 is a date for starting the college, not granting the affiliation. This, it has no legal entity. The legal entity, legal status comes only when it is
Yes, we
granted the
understand-
affiliation.
We understand that on the day this coming into force of that is in 18 says
17/8/1995.
17/8/1995, this institution was not affiliated, the college was not affiliated by the Assam University. Therefore, it cannot be treated into existence. That's all.
Therefore, it cannot take the benefit of extension period for
Fine.
submitting the application.
That's all.
That is the condition, my lord.
And therefore, whatever the degree granted by it or recognition, that degree can't be recognized. This
Yes,
is what your
that is the
argument
settled position of law.
We understand that.
I am taking your
Now-
lordship.
Yes, we'll go through these provisions. Don't waste the time of the court.
No, my lord, unless I'm allowed to submit, my lord.
We'll go through this. Please try to understand. If we say
Page
you
29.
confine your argument, we have understood your argument, that's enough.
No, I'm in support
No,
of that
we are
argument.
not-
I have to place the no, my lord.
Please don't force the court to make any observation, please. We have understood your, whatever it may be, there is no need to go through all these provisions that what is the affiliation provision, if it is not affiliated, and your argument we understood, that's all. Yes, anything else?
My lord, clause 11 of.
Mr. Pugasto, your client was the petitioner, writ petitioner.
Yes.
What was his cause of action? What was his
Because,
demands?
my lord, he was aggrieved because this opponent party was, my lord, selected for, was, had his degree been declared valid, my lord, he would be declared as principal, my lord. That is that.
No, your prayer was that he should not be given any increment, any service benefit.
Yes,
And you were the principal at that point.
yes.
So how can he be principal in the same school?
Because he had, serving in the same school, my lord. He had challenged my promotion to the post of principal.
So this is a return gift to him. You are using the court's forum for all this private vendetta.
No, this is not private, this is illegality, my lord. This is
Well, what business you are already holding the post of principal.
not my.
How are you bothered whether he gets?
For his case, my lord, my principal appointment has been quashed, my lord. Quashed, my lord.
And therefore, without restoring
There-
that, without, since it
before
was
that-
quashed, therefore now you have filed this.
He
counter
challenged my
affidavit that
degree,
is
he
not
challenged my
entitled for
degree and this level
allowed
court,
that-
my lord, on the same ground, my lord, my lord, rejected my,
Yes, any other argument, this argument we have understood.
and
That
my
the
lord,
college was not affiliated, degree can't be recognized, that's all, आगे बताओ.
college was, my lord, the clause 11 of the affiliation clause says, my lord.
It was not affiliated, this is what your submission is?
Yes, this is.
Yes, that's all, then why to go through all
And
these clauses and all?
therefore,
Where is the need to elaborate this procedure of affiliation and all? It was not affiliated, not affiliated.
they are not affiliated, therefore it does not come, the college cannot take the benefit of period of extension.
That we already taken
It
into
is
consideration. We
period-
have noted that argument. Any other argument?
My lord,
Any other argument?
your lordship, my lord, earlier occasion decided the case of Musabir Ali on the basis of Bhupendranath Tripathi. In the
Yes.
similar circumstances, Madras High Court, Madras High Court decided one case, my lord. I have.
So we follow the Madras High Court,
No,
will not follow our judgment, okay?
I cannot say your lordship will follow, but in that judgment, my lord, the Honorable Madras High Court has clarified that those degrees those colleges which had offered the degrees prior to 1993, prior to the 17/8/1995, and those the colleges which had the affiliation and permission from the university concerned prior to 17/8/1995, those degrees are valid. But in respect of other degrees which offered by the college concerned, but on the day of admission of the NCT, my lord, it was not.
So you are relying on Madras High Court judgment?
Not
Give
only
it-
Madras
we'll
High Court,
read
I
it.
have
Don't
given the-
elaborate it. We'll read it.
I have given the citations of my lord, your lord.
Yes, in this compilation it is there.
Yes,
We'll
lordship.
go through it. Yes.
In fact, our, my lord, this honorable court at page 47, single judge case, my lord, this is not decided, just pending, page 47, where, my lord, the honorable single judge has clearly stated, page 47, a B.Ed degree to be in existence on the date of coming into force of the NCT Act 17th August 1995 means that said degree college had the requisite permission and affiliation from the concerned university within whose jurisdiction it applied for permission as well as affiliation. In absence of both permission and affiliation, a college cannot be said to be in existence in proper form to render education and confer degrees.
Yes.
WPC, my lord, 1368/2023 pending.
Anything else?
I have given, my lord, in support of this, my lord, I have given Supreme Court judgment, my lord.
We'll consider that, certain. We'll consider. Order is up.
All right.
Item 24 to 26.
Lordship, in item number 25, we have been newly engaged in this matter, your lordship. We require some
Item
time.
number?
25, your lordship.
This is a tied together. 22, 25, 26.
Point of determination. Okay.
Learned single judges differed with the other coordinate bench, is it?
Lordship, the reference order is of 22/2/2023.
So what do you want?
Lordship, the matter may come up after a week, your lordship. Okay.
Well, after we'll hear it after summer vacation.
Malad, there's some urgency. Let it be fixed on 2nd, Milord.
What's the urgency? What's the urgency? So matter is pending since 2020.
It is pending since 20, Milord.
Oh.
Regarding appointment.
2020. After summer vacation.
All right.
Item 28.
In this case, by last order, the department was directed to produce the original records of the case. Lordship, I request
When?
Lordship, because I mean,
Direction was there.
Yes, Lord.
Original records, yes. What happened then?
I required some time because record has to come from Karimganj.
एक साल तो हो गया 9/6/2023 का this order is of 9/6/2023
This order escape on notice. Yesterday I met requisition.
by foot on foot गया है क्या लेने के लिए
Lordship,
पैदल गया है लेने के लिए
no, Lordship, I'll get it, Lordship may take up next week. I'll get the record.
Summer vacation.
Item 32.
For the respondents, I think the petitioner is there.
Mr. Advocate General is here.
Yes, yes, Lord.
Is here
I'm outside.
today.
He is here, Lord.
Material Lordship. The single is on the way, Lordship.
The password next cases.
My lord, I'm sorry, man. My lord, this is an appeal by the state. State was the respondent before the Honorable Writ Court. State is the appellant before your lordship. My lord, this matter was originally filed and heard at Sikkim High Court. Thereafter, my lord, in the circumstances, my lord, we have been assigned.
Take your own time, please. Have some water and all.
My lord,
Settle down, please.
my lord,
Be settled down.
my lord, I'm obliged, my lord. My lord, honorable single bench order is at page 41. My lord, I was just thinking, the subject matter is a little, my lord, is not a pan-India subject matter. The lordship knows Sikkim has got a peculiar history of its own. The merger of Sikkim, then Article 371. My lord, there is some peculiarity of laws. When I was going through the brief, something struck me. And my lord, then I had to go through the accession treaty and other things. My lord, can I take your lordships briefly to the records first? We can go to the single judge's order also, but then I have to take your lordships again to the single judge's order after we see the background, my lord. My lord, pray if your lordship allows me, we'll go to the background first.
Yeah.
My lord, Sikkim has got a peculiar citizenship or domicile law. My lord, it's not akin to Dadin Jammu Kashmir pre-370 abrogation, but it's little different. Different in the sense, my lord. Sikkim was earlier ruled by it was a princely state, my lord. So Chogyal was the head. He was the king, Chogyal. Now, during Chogyal's time, he was the sovereign. There were some, my lord, laws promulgated by Chogyal, which under the merger treaty has been saved. So these are law in force till date. My lord, I can broadly classify for the purpose of our case, my lord, the law first to the citizenship domicile issue,
Then, my lord, the employment issue, which is the crux of the matter. My lord, there was a regulation of 1961, which your lordship would get at page 94 of the brief. Page 94 of volume A, that is the, my lord, writ appeal. My lord, page 94 is annexed 2 colleague of the writ petition. No, writ appeal, heavier.
94 of the rate appeal, this.
My lord, yeah, of the writ appeal file. This is probably volume A of the bounded volume. There are some bounded volumes, man.
Annexure, A2. Annexure A2.
Annexure A2.
Yeah.
My lord. My lord, this is a regulation called Sikkim Subjects Regulation of 1961. This is amended subsequently, but this is issued by the then Home Department of the Government of Sikkim, dated 3rd July 1961. It is published in the Sikkim Darbar Gazette Extraordinary, and this following the proclamation of Chogyal of Sikkim, the king, my lord, is been notified, where it is expedient to define clearly the status of Sikkim subjects and to make provision for acquisition and loss of such aforesaid status. Now, therefore, the Chogyal of Sikkim has been pleased to make and promulgate the following regulation. Short title is Sikkim Subjects Regulation is the short title, my lord. It extends to the throughout the territory of Sikkim. Commencement. The regulation shall come into force on such date as may be appointed for this purpose by the Chogyal of Sikkim. My lord, at page 98, your lordships will find it was brought to effect on and from 3/7/1961. My lord, certain persons domiciled in Sikkim territory at the commencement of the regulation to be Sikkim subjects. Every person who has his domicile in the territory of Sikkim immediately before the commencement of this regulation shall be a Sikkim subject if he, A, was born in the territory of Sikkim and is resident therein, or B, has been ordinarily resident in the territory of Sikkim for a period of not less than 15 years immediately preceding such commencement, provided that in counting the said period, 15 years, any absence from the territory on account of service under the government of India shall be disregarded. Or is the wife or minor child of a person mentioned in clause A or B. Lordship will kindly see the devolution part stops at wife and minor child. Then provided that a person shall not be a Sikkim subject under this section unless he makes a declaration to the effect that he is not a citizen of any other country at the time of inclusion of his name in the register of Sikkim subjects to be maintained under this regulation. Provided further that in the case of a minor of the person, declaration made by the guardian. Explanation. No person shall be deemed to have his domicile in the territory of Sikkim unless he is a person who has made Sikkim his permanent home and has served, and is, my lord, this should be severed, is not served, and has severed, severed his connection with the country of his origin, such as by parting with his property in that country or acquiring immovable property in Sikkim. Provided that a person shall not be deemed to have been permanent resident of Sikkim if he indicates his intention of returning to his country of origin by keeping his life interest therein, even though he might have parted with his property in the country of origin, and mere parting will not be regarded as a proof. Then again this, my lord, the wife and minor children of a person having his domicile in Sikkim shall be deemed to have domicile in Sikkim for the purpose of this section. My lord, we come to 4. Certain persons do not domicile in Sikkim to be Sikkim subjects. Any person who has not voluntarily acquired the citizenship of any other country, though not domiciled in Sikkim, may, on an application made to the authority and prescribed rules, under this regulation be registered as a Sikkim subject if he is a person whose ancestors were deemed to be Sikkim subject prior to the year 1850. My lord, then status of women who are married, they are not to be treated as Sikkimis. Then certain persons who are not Sikkim, my lord, subjects. My lord, everywhere your lordship has seen, they speak of a register. The register is framed under the regulation under the statute, my lord.
Register?
There's a register of, my lord, Sikkimis, persons of Sikkim origin. Lordship will see in the first, my lord, regulation clause 3 itself in the bottom, page 94, C. If the wife or minor of a person, minor child of a person mentioned in A or C, provided that a person shall not be a Sikkim subject under this section unless he makes a declaration to the effect that he is not a citizen of any other country of the time of inclusion of his name in the register. Every time, my lord, they speak of a register to be maintained under this regulation.
Who has to maintain this register? Regulator?
My lord, under this regulation, the authorities are to maintain a register of almost like, my lord, our national register of citizens. They have got a register of people of Sikkimese origin. Sikkimese origin. That's how they term it. My lord, your lordship will get a little more of this. My lord, kindly come to page 97 at the end of this regulation. 12. Miscellaneous, my lord, offense punishment 12. Evidence of status as Sikkim subject. The government of His Holy Highness shall prepare and maintain a register of Sikkim subjects in accordance with rules to be framed under this regulation, and the entry of a person's name in such a register should be prima facie evidence of a person's status as a Sikkim subject. My lord, lordship says page 98, bottom. This regulation was given effect to. This comes to effect, my lord, by virtue of this notification, pursuant of section 2, so and so promulgated Home Department, so and so His Highness Maharaja of Sikkim has been pleased to order that the date of commencement shall be from the date of proclamation. That is 3rd July 1961. My lord, kindly come to page 99. That's the rules framed under the regulation. Only for the purpose of understanding, my lord, what is this scheme all about. My lord, this is the Sikkim rules. My lord, lordship may kindly come down, skip declaration under section 3 of the regulation. No, my lord, 3.1. Every person of A who is qualified to be Sikkim subject by virtue of the provisions of clause A and B of section 3 of the regulation shall make the declaration required under this provision. Then, my lord, kindly skip 2, 3. The executive officer, together with this recommendation, 4, the chief executive officer, if he is satisfied that the person concerned qualifies to be a Sikkim subject under section 3.1 of the regulation, shall cause his or her name to be entered in the register of Sikkim subjects. So, my lord, here is all about the register. Lordship may skip to page 100. Kindly come to rule 6.2. 6.2, page 100. The chief executive officer may, on being satisfied that he fulfills the condition of being registered or naturalized, as the case may be under the regulation, and the applicants put forward so and so, accept this application. My lord, rule 7 of the speaks of the registration of birth under the commencement of this regulation. This also speaks of the register. My lord, we can skip it for the time being. Lordship, kindly come to page 178. Sikkim terrain is otherwise very hilly, my lord. So, my lord, I will also beg your lordship's permission to go a little slow.
Yeah, please.
It's hilly terrain, my lord, and unknown to me. My lord, this is a notification from the Government Gazette of Sikkim of June 21, 1975. My lord, it is already a part of India. The transition process has started. We now see, my lord, how they deal with this domicile issue, which is, my lord, alien to our Article 5 of the Constitution. This scheme is alien. We see, my lord, how they reconcile this. Government of India and the Ministry of Home Affairs by notification dated 16/5/1975 published for general information. In pursuance of the notification, Government of India, Ministry of Home Affairs of 16th May 1975, central government hereby appoints 16th day of 1975 as the date on which Citizenship Act shall come to force in the state of Sikkim. Then, my lord, kindly skip the next two. Kindly come to SO 217E. In exercise of the powers conferred by Section 7 of the Citizenship Act 1955, the central government hereby appoints, makes the following order, namely, this order may be called the Sikkim Citizenship Order 1975. Every person who immediately before 26th day of April 1975 was a Sikkim subject. They also use the word, my lord, Sikkim subject. Under the Sikkim Subjects Regulation 1961, shall be deemed to have become citizen of India on that day.
The Sikkim became part of India in the 72.
75, my lord.
75 only.
April
The
75.
precise date,
My lord,
precise date.
I think 16th. 16th of May, 1975, it was, my lord, the process
It
started
became part of it.
sometime in April. It ended up, my lord, with the Treaty of Annexation in 16th May, 1975. That's the date. Sikkim became part of India.
So this is the instrument of accession.
No, this is not the instrument of accession. Instrument of accession is, my lord, I'll take your lordship to that. Instrument of accession for us, it is necessary, my lord, because some statutes were saved. But, my lord, somewhere, my lord, given up, and that I'll take your lordships to right now. My lord, kindly come to.
Those statutes saved includes this Sikkim Subject Regulation Act.
No,
1960.
my lord, fiction. There's a fiction. If your lordship kindly comes to the next page, 179. This is the adaptation order of some laws, my lord. Kindly see.
Okay. Yes.
In exercise of powers conferred under clause 1 of the Article 371F of the Constitution, the President hereby makes the following order. The order will be called the Adaptation of Sikkim Laws Number 1 Order 1975. It shall be deemed to have come effect on 26th day of April 1975. In this order, appointed day means 26th day of April 1975. Existing law means any law in force immediately before the appointed date. Law includes any enactment, proclamation, regulation, etc., etc. My lord, General Clauses Act is applicable, my lord. My lord, kindly come down after Sikkim government, state government. 4. Lordship got, my lord.
Yeah.
4 at the bottom. As from the appointed day, the laws mentioned in first schedule to this order shall stand repealed. I'll take your lordship to that. But before that, the laws mentioned in second schedule of the order shall, until altered, repealed, or amended by the competent legislature or other competent authority, shall have effect subject to adaptation, modification, and so on and so forth. My lord, kindly come to the next page, 180. Sikkim subject regulation.
180.
My lord. Lordship, go ahead.
Schedule.
This is in the first schedule.
First schedule.
First schedule. Office order so and so, so and so. The Sikkim subject regulation 1961 is repealed, my lord. The Sikkim subject regulation is repealed. We have to see the effect now. Kindly come to page 188.
Yes,
188.
188.
Yes. We were at 180, now 188. My lord,
188.
188. My lord, this is a gazette notification again, dated 3rd of April, 1989. This notifies a Government of India notification dated 20th of March, 1989. Notification number 214E. In exercise of powers conferred under Section 7 of the Citizenship Act, Central Government hereby makes the following order to amend the Sikkim Citizenship Order 1975. Namely, this order may be called the Sikkim Citizenship Amendment Order 1989. Now, the Sikkim Citizenship Order 1975, my lord, that was in page 178. We have just glanced through. Sikkim Citizenship Order to paragraph 2, the following proviso shall be inserted, namely, provided that any person whose name was eligible to be entered in the register maintained under the said regulation, but was not so entered because of any genuine omission, shall be deemed to have become a citizen of India on that day, if so determined by the central government. My lord, the regulation was repealed, but the register was kept. Because without the register, my lord, the Sikkim Citizenship Order doesn't have any meaning. People who were registered as the persons of Sikkimese origin, they were held to be automatically Indian citizens. Plus, these are Indian citizens who are people of Sikkimese origin. Now, my lord, by this, it is further amended that on that day of making the register, if any person's name was genuinely omitted, then, my lord, their names can be entered by a way now to be determined by the central government of India. Now, what does central government do? Central government makes a committee, page 189. Next page, my lord.
Yes.
This is again dated 3rd of April 89. The central government do hereby constitute a committee to look into the case of genuine omissions in the name, in terms of the Sikkim Citizenship Amendment Order 1989. The committee shall consist of so and so. The committee is authorized, my lord, these are Registrar General of India, Additional Secretary MHA, Joint Secretary MHA, Joint Secretary Northeast MHA, Additional Secretary and Home Secretary of Sikkim, my lord, and Vijay Advocate General. He was the first Advocate General of the state. Now, my lord, the committee is authorized to invite applications so and so, so and so. Committee, my lord, last, the committee upon being satisfied shall recommend the names of such applicants as are considered genuine omissions in terms of the Sikkim Citizenship Amendment Order 1989 to the Government of India for issue of necessary orders. They can only recommend, my lord. My lord, kindly come. My lord, page 190 also is little relevant. Page 190. This is an annexure to the
MHA order.
MHA order, my lord. My lord, lordship may kindly come to D. Probably others, for the time being, persons holding a regular government job before 26th April 1975 provided that the appointment has not been made under exception clause pertaining to non-subjects and his natural descendants. So, my lord, these are also people whose names can be considered. My lord, the next page. I can just cut it short. This committee sat, my lord, twice. In the first sitting, they recommended 40,083. 40,083 names.
This figure can you collect this figure from where?
Yes, my lord. Page 191.
Yeah.
My lordship may the following order. Whereas the merger of Sikkim, my lordship may skip the first four. My lordship kindly come to third from the bottom.
Yes.
Whereas the government of Sikkim reviewed all such cases of genuine omission and recommended the names of 74,966 persons were considered eligible for being included in the register maintained so and so. Whereas central government of carefully considered examined cases of 40,083 persons whose details are given in the enclosed list. The central government, after careful consideration of all the facts and documents produced in respect of 40,083 persons, hereby determines that they were eligible to be included in the register maintained under the Sikkim subjects regulation. So, my lord, in this phase, 40,083 persons' names are included. My lord, kindly come to page 192. Lordship may skip the, this is a notification dated 15th of April, 1991. Lordship may kindly skip the 1, 2, 3, 4.
This again, this order 192 is
Again, another set of people.
another set of people. Okay.
Yes.
First, in the first sitting,
40,083.
74 and 40,000. 74,966.
No, my lord, 74,000 was the total names given.
Taken into consideration.
Taken into consideration, the central government agreed to 40,083.
Okay, out of this 74,000, only 40,000.
My lord,
allowed by this.
My
Okay.
lord, my lord. In the next sitting, the central government notifies, my lord, here, again, another 33, my lord, lordship may come down to the last paragraph of page 192. 192.
Yes.
33,000, my lord, whereas the central government carefully examined the cases of 33,348 persons more whose details are given in the enclosed list have found them eligible to be included in the register maintained under the Sikkim Subjects Regulation 61. The central government, after careful consideration of all this introduced, so in respect of all these 33,348 persons, hereby determined that all these persons be deemed to have become citizens of India with effect from 26th April 75 in terms of Sikkim Citizenship Order 1975. My lord, the total strength now is at page 193.
Yes.
Lordships may skip the first four. Notification is the following order dated 10th of January 1994. Whereas after the merger of Sikkim with the Union of India, the central government promulgated the Sikkim Citizenship Order according to which every person who immediately before 26th day of April 1975 was a Sikkim subject under the Sikkim Subject Regulation 61 shall be deemed to have become citizen of India on that day. Whereas it was brought to the notice of the central government that there were a large number of persons who were eligible to be entered in the register maintained under the same Sikkim Subject Regulation 61, but were not so entered because of genuine omissions, where the central government issued Sikkim Citizenship Amendment Order 89 providing that such cases of genuine omissions should be reviewed, and if so determined by the central government, these persons should be deemed to have become citizens of India on that day. Whereas the central government in the Ministry of Home Affairs, after due consideration of the applications of other relevant factors, determined 73,431 persons were Indian citizen with effect from 26/4/1975 under the Sikkim Citizenship Order 75. Whereas, as per the, my lord, this 73,431, if I'm not wrong, is 40,083 plus 33,348 by the previous two orders, my lord. Whereas, as per the decision of the committee on 1/6/1990, 344 cases which were found to be doubtful by the subcommittee, the ministry returned 344 applications which have been categorized as disputed. Whereas these 344 applicants were re-verified after completion, all submissions were received by the central government to carefully consider the cases of 1290 persons whose details are given in the enclosed list and are found eligible for included in the register maintained under the Sikkim subject. The central government, after careful consideration of all the facts and documents produced in respect of this 1290 persons, hereby determined that all these persons be deemed to be. So my lord, totally 73,431 plus 1290 persons were included as Sikkim subjects under this process. My lord, this is where we briefly, my lord, see the transition from Sikkim subject to Indian nationality. My lord, kindly come to that core issue of employment now. Because this is the crux of the matter. And we see and read Article 16 also in the light of these provisions. Because equality clause as available to Article 16, Revit 14, has been redefined for Sikkim, my lord. I'll take your lordship to the Supreme Court verdict also in this case. My lord, for the purpose of employment, we can start from the rules of 1974 at page 136. Page 136. This is Annexure 8, my lord. My lord, this is a rule called Sikkim Government Establishment Rules 1974. In exercise of the powers conferred by the proviso to Article 309 of the Constitution of India, Government of Sikkim is pleased to adopt the Sikkim Government Establishment Rules 1974. This is, my lord, a Sikkim time order. This is adopted. As the rules regarding recruitment and conditions of service of persons appointed to the service and post in connection with the affairs of the state of Sikkim with modification set in herein below with effect from 26th day of April 1975. Title commencement. These rules may be called the Sikkim Government Establishment Rules 1974. It comes into effect on and from 1/4/1974. Application. These rules shall apply to all government servants to the state to the same extent as the Sikkim Government Service Rules. The provision of these rules shall be regarded as supplementary to those of the Sikkim Government Service Rules. And go back in.
June 1975, there was a merger of Sikkim.
16th of May.
May,
16th of
yes.
May, 75. With the merger of the princely state of Sikkim with Government of India. Before merger, how this 309 proviso to 309 rules were framed? At that time, the Indian Constitution was not applicable.
What is that thing?
This in exercise of powers conferred on 309
309
of the Constitution of India.
My lord, this, my lord, I'm coming to this. Now, this adaptation, in fact, was made in 1980. Lordship will come down a little bit.
Insertion.
Insertion.
Wide establishment 1980.
80. My lord, the entire first part of the notification, the preface, was inserted. This rule was there in vogue.
Earlier, what was the this preface? Before
My lord,
substitution or before amendment.
My lord, Right.
Must be there, first April 1974.
This I have to update myself. This preface is my lord, is very relevant to you.
And by a insertion, how can you predate a regulation or
Enforcement,
antedate it? How?
My lord,
enforcement, was predated. In fact, this, one of the clause two says, subsection one, clause two says, they shall come into force with effect from 1st April 1974.
because it existed prior to merger.
But here in the preface, it says, the persons appointed as a post of connection with the affairs of Sikkim state with modifications set out here below
my
with
lord.
effect from 26th April 1975.
True. My
That's
lord,
the number.
as it is, my lord, I understand. It has not escaped your lordship's judicial scrutiny, but it escaped the eye of the Babu, my lord, who drafted it.
It seems like.
It is true, my lord. But my lord, in a nutshell, what I understand is, my lord, mutandis mutandis. They have just kept it and added the first part, that we make it a rule under 309. We will not do any further exercise. Jo hai, so hai, we are making it a rule under 309. But my lord, I will update myself if there was any preface prior to this insertion of 1980. My lord, what is relevant for the purpose of our case, your lordships will get it at page 141. And this has undergone the judicial scrutiny of Honorable Apex Court and passed the judicial test. Page 141. My lord, this actually starts, this is a part of clause 4, and what we are reading now is clause 4.4. It starts at pre-page 41, 42, 43, and this is 4.4 actually. Although 4.4 is not written, it's 4.4.
4 or 4.3?
No, 4.4, my lord. Page 141, top appointment. Actually, this is not an independent 4. This is part of regulation 4, 4.1, 4.2, 4.3, and this is 4.4. So typographically, it is not shown that way. It's that. Page 1. Right. My lord. Appointment. Appointment to service under the government shall be by one or both the method indicated below. Direct recruitment, promotion. Direct recruitment shall include appointments on contract and appointment on deputation. Proviso. This is important, my lord. This is understood. Provided these two types of appointment shall be made having due regard to the exact nature of specific duties and responsibilities and the qualification required for the post, and further provided that 1. Non-Sikkimese nationals may be appointed only when suitably qualified and experienced Sikkimese national are not available, and number 2, replacement of such appointees by suitable Sikkimese candidates may be made as and when available. Mutually agreed terms shall apply to all the appointments on contract for appointment on deputation. Formal agreement to this term shall be between the government of Sikkim and the parent organization of the officer through the government of India, not directly with the officer. My lord, lordship may skip the additional note. This rule 4.4, as I told my lord, had undergone the judicial scrutiny of the Honorable Apex Court and is reported in AIN 1994 SC 2342. My lord, we'll go to that a little later, my lord. When I read this rule, my lord, this editor's note was not available with me. So I was a little shocked. I didn't have the background of this Sikkim, my lord, annexation treaty, some rights being kept alive and other things. This prima facie, my lord, I can confide to your lordship, my lord, the previous bench before whom I was arguing this matter, I could not argue, my lord, because my lord was, that was too good a day for me to argue this case. That was the day when my lord, Supreme Court Collegium news came. So I would like to about my hearing on that. No, my lord, the same question fell from their lordships. What is this? No, my lord, this editorial note immediately was referred to, and then, my lord, we went to the Supreme Court case. My lord, kindly come to now page 185. Keeping this regulation alive, my lord, at background, 185. We'll read 185A. There's a typographed true copy. My lord, I can tell, my lord, these series of notifications were the subject matter before the honorable single judge, which now prevails before your lordship. But the root with the background of that regulation starts from this 1976 notification.
Yes.
And these are not under challenge. What is under challenge is the subsequent final notification. In order to ascertain the residential qualification of candidates who can claim themselves to be locals at the time of seeking employment, it has been decided that candidates should be asked to mention whether their parents' name have been recorded on or before 15/5/1975 in the relevant government register. My lord, just for my understanding, I'll just remind myself. Lordship remembers, register.
1961.
Yes, wife and child. It stops at that. So the question here is, the candidate should be asked to mention whether their parents' name has been recorded, not grandparents. Parents' name has been recorded on or before 15/5/1975 in the relevant government register. This is the first notification, my lord, which provides a guideline as to how clause 4.4, that 4.4 has to be applied. Sikkimese, non-Sikkimese. My lord, kindly come to next page, 186. Lordship would kindly travel to the middle of the right-hand side. Middle. There's a notification number 285G establishment dated 28th of January 1980. Middle, my lord.
Middle.
28th of January 1980, Gangtok. It is hereby notified for information that all head of the head of the department that domicile stroke residential certificate issued by the sources other than district collector shall not be accepted as valid. First we see, my lord, whether your parents' names are there, not grandparents. Parents' names are there. Then who can verify this? Only the district collector. Yes. Kindly come to page 197, the next page. This again an independent memorandum. It's dated 9th. Yes. This is dated 9th of April 1981. Lordship, what is, my lord?
Yes.
9th of April 1981. Memorandum.
Mr. Day.
My lord, my lord.
We are approaching the lunch break now.
My lord.
When we resume after the lunch break,
I think that
we'll request you to kindly give us a landscape of the litigation in a nutshell. What exactly is the issue? We have been reading this notification, that notification. What is the issue and what is to be decided? What is the formulation? What is the submission?
We are just at the doorstep.
What is the controversy here?
I was just thinking, if I just give a resume sort of thing, my lord, the subject matter is such, I'll get lost.
That would be better than what the actual controversy is.
My lord, once we go through the judgment, your lordship will see with this background, each of the lines are in controversy. The controversy starts from the first line of the
What was the
judgment.
actual controversy raised before the learned single judge?
My lord,
Learned single judge might have decided
my lord,
that way either way.
who is a Sikkimese, who is not a Sikkimese, vis-a-vis this clause 4.4. That's the crux of the matter.
So Mr. Day, Mr. Chaudhary, we have commenced the hearing. But my lord, the Honorable Chief Justice is of the view and I subscribe to that. It will be good if you could give us a short synopsis of what are the.
Mine is already on record.
And
My lord, my one is not on record.
It's already on record.
so this matter will not be ending today. So we'll resume and continue it on Tuesday, next Tuesday.
Next.
Just give us a, since
Deprive us
resume,
Lordship will not deprive us on Tuesday.
What is that?
Fourth. They want to enjoy the sixth. Let it be on sixth, man. We have to have that, my lord, and maybe attending one of those short matters and go to the bar room and have a look at the TV.
My lord, I was just.
That liberty we are praying for.
I was just hoping so, because my lord, some predicament in the first part of June, some very serious predicament for me. My lord, I was actually hoping so. If we can't, we won't be finishing today. Can we resume tomorrow?
11th June.
Yes.
Can we resume tomorrow? I'll give a brief note, my lord, and thereafter.
Tomorrow, in fact, today is the hearing day. That's why only we thought we'll hear it and we prefer it to have a hearing day.
Yes.
Because it would be difficult for us to complete
lord,
the
my
board and then resume the hearing, but that.
My lord, my predicaments. My lord,
11th is also hearing day.
Yes.
my lord, in fact, my lord, up till 12th, I'll be away, my lord. Away from anywhere.
13th?
Yes, yes. 13th we can.
Well, our written argument is already given.
Just want a.
Well, we have given the
Instead of-
facts, the submissions and the issue which are involved.
And the annexures which they are relying on, page numbers. So
That I have given in my written argument with the page numbers.
No,
of-
but about him.
My lord, can it be 24th, my lord? He is suffering bereavement, my lord. He has got, they have got very elaborate.
Fine.
24th, my lord, is a Monday.
Achha, where is the written argument? All of the belek file.
Our written argument too.
It is there.
24th,
Belek file on devotion.
Entire background, everything I have. In fact, my lord, this matter was heard by two former chief justices.
All of them have gone to Supreme.
All of them to go to Supreme Court.
Normally
I
history
wonder
repeats itself.
Whether we are going to argue the matter again.
Only that.
And one of the council was arguing, he's also on the bench. Okay, Mr. Krishnan, Unni Krishnan Naik. 24 June, Supreme Court be. My lord, what had happened?
And you
My lord,
please
that-
give us the,
My
just
lord-
supply the resume within next week or something.
Yes.
Well, can I make one point, my lord?
Yeah.
Initially, there was no stay.
Okay.
Subsequently, my lord, after a long time, a stay was granted.
Not yet.
Oh, no, I'm sorry. Then, my lord, we initiated a contempt proceeding before the land single judge. Now that order has been stayed. I'm sorry, I'm stand corrected. So that's why, my lord, they're issuing, my lord, they're not giving admission. Our children are suffering.
With this understanding on 24th and then thereafter.
Let it be
28th,
little earlier.
26th, whatever it may be, we'll hear it.
My lord,
It
24th,
little
your
earlier.
lordship can keep
Either
it.
even if it is possible, day to day, at the
Yes.
cost of others, we'll hear it.
My lord, I don't think both of
No,
us will trouble your
It
lordship
is
for
a-
more than.
I can tell one thing, my lord, this is a matter which is a very serious matter and involves fine constitutional points, my lord. In fact, it is our privilege that I got an opportunity
My
to
lord.
No, sir,
argue a matter like
we
this,
also
to be
would
honest.
like to,
Yes.
we also would like to deal with it. And that's why only.
My lord, on this issue,
My lord,
My
we'll
lord, which
find out the written argument for your lordship.
I'll do
My junior will do that.
No, we'll.
my lord, before I start on the next day, 24th, it'll be there with your losses, my lord, from my side also.
And all this resume.
Absolutely.
and everything.
Absolutely.
Absolutely.
24th is the Monday,
24th is a Monday.
then 25th. 25th.
Yes, my lord. Yes.
25th June.
Yes.
So top of the list, madam. Yes, so we'll take this matter. Certainly we'll start on this matter and we'll try to finish it in the next whatever 2-3 days or 1 day or whatever.
I think 2 days it will be enough. My learned friend.
Yes,
can-
yes, yes, yes.
We'll also
I agree,
get
madam.
some time in.
2 days should be enough.
Certainly.
Deeply obliged, sir.
May I please, Your Lordship? This is state appeal, Your Lordship. Before.
Yeah.
Before I take Your Lordship to the impugned judgment and order, Lordship, I'll just put the facts in a little bit, a small nutshell, Your Lordship. Lordship, what has happened is that Central Government Ministry of Industries and Commerce has come up with a policy. This is called Northeast Industrial and Industrial and Investment Promotion Policy 2007. So it was basically formulated to promote industries in the northeastern states as well as create some employment. So thereby they wanted to give some fiscal incentives to this northeastern states. So under this policy, they have formulated certain schemes. Schemes like capital investment scheme, then interest subsidy scheme, insurance subsidy scheme. There are 5-6 schemes they have formulated under this policy. Now the policy concerned in this case is Lordship that Central Capital Investment Subsidy Scheme. Central Capital Investment Subsidy Scheme.
Central Capital
Investment Subsidy Scheme of 2007. So under this policy of the scheme, Lordship, what happens is that the plant and machineries they put in by a manufacturing unit. So those plants and machineries, so 30% that capital investment they do in the plant and machineries, 30% subsidy is being given to the units. Now, in this case, Lordship, what has happened is that the company has there is a pre-requirement that you'll have to be registered prior to going for setting up of your industry or unit. You'll have to pre-register under the scheme. So this unit was pre-registered. Then they have supposedly gone for commercial production, and they have submitted their application for subsidy of 30% because it was a new industrial unit. These two categories of units can get the benefit. One is the new industrial unit, and one is the existing industrial unit. So existing industrial unit, if it goes for substantial expansion, diversification, or modernization, then also they get certain percentage of the benefit.
Subsidy or whatever.
Yes, Lordship, whatever they get. So they have gone for commercial production. Now, after the commercial product, they have gone for commercial production. They have filed an application stating their claims there. Now, it has been recommended initially it has to be recommended by the General Manager of Industries and Commerce Department. So he is the recommending authority. Basically, he recommends it, and there is a specialized body.
Recommendations means only to reference or made some recommendation whether he is entitled for benefit or not.
They do it. Lots of whatever the claim is there, out of that they check up, they do a field visit, and after the field visit, they recommend certain portion of the amount. Now, in this case, also recommendation was done that SLC is the high-powered body here, and this SLC is the state level committee consisting of Industries and Commerce Department, Finance Department, and all this committee is there. So, committee has done. Committee has reduced the recommended price, stating that certain machineries, plant and machineries have been brought into the site later on after the commercial production. After the commercial production happened, certain machineries were brought in later on. Those were installed later on. So those machineries will not be eligible for any benefit under this scheme. This fact
has not been noted by the district committee.
District committee also at that point of GMA is already recommending.
Since the district committee has visited, inspected the site.
they have visited Lordship. The GM is the only the recommending authority, so he has recommended. So like state level committee is the ultimate authority which will scrutinize all the papers, and after that they will decide whatever will be the amount eligible for the subsidy. So they have deducted certain portion of amount, stating that those machineries were substantial after going for commercial production, those machineries were installed. So subsequently, those have been installed, so those were not eligible. So this is the Lordship issue which has been challenged by the respondents before the Honorable Single Judge. The Honorable Single Judge has opined that those machineries, since they have placed the orders prior to commercial data production, so those will be eligible, so that those should be considered. So the orders have been placed prior to commercial data production, so those should be considered. Now, our grievance, Lordship, state's grievance in this appeal are that, first of all, Lordship, couple of provisions of the policy and the scheme, those have not been considered in their proper perspectives. Like there are certain definitions of plant and machineries which will be eligible for the subsidies. All the plant and machineries may not be eligible for subsidies. And there are certain definitions of which will be, there is an eligibility criteria under the scheme. So that those units has to come under that. Then only they will be eligible. Now, Lordship, I will take your Lordship to that policy, Lordship.
Please, what are those findings of the learned single?
Lordship, I'll take your Lordship to the findings.
From para number 29 of the.
Lordship, I'll take your Lordships to directly to page 204. And the relevant para is page 209, Lordship. Because Lordship, para 25, I just wanted to read it out because,
yeah,
as I stated, Lordship, there are certain definitions which have not been taken in the proper perspectives. The para 25.
25, yeah.
Para 25, Lordship. May I read it, Lordship? Government of India in the Ministry of Commerce and Industry issued notification dated 27/7/2007 introducing the scheme of CCISS 2007 with a view to accelerate industrial development for the northeastern region. It was mentioned that it would come into effect from 1/4/2007, remain in force up to and inclusive 31/3/2017, so 10 years. Clause 4 of the notification deals with definitions. Industrial unit has been defined under clause 4A to mean any industrial undertaking suitable servicing unit other than that run departmentally by the government. As per clause 4B, new industrial unit means an industrial unit for setting up of which effective steps were taken prior to 1/4/2007. Under clause 4C, existing industrial unit means an industrial unit for setting up of which effective steps were taken prior to 1/4/2007. Substantial expansion has been defined under clause 4D to mean increase in the value of fixed capital investment in plant and machinery of an industrial unit by not less than 25% for the purpose of expansion of capacity, modernization, and diversification. Effective steps has been defined under clause 4E to mean any one or more of the following steps. That is 10% or more of the capital issued for the industrial unit has been paid up. Any part of the factory building has been constructed. 3, a firm order has been placed for any plant and machinery required for the unit. Other clause 4F, fixed capital investment has been defined to mean investment in plant and machinery for the purpose of the scheme. Now, Lordship, for a moment, Lordship, I'll pray your Lordship to take it down that these definitions, Lordship, these definitions have been amended later on. So this definition, while writing this judgment and order, my Honorable Single Judge has not taken into consideration the amended definitions of this in the new industrial unit, existing industrial unit, and substantial expansion. Then Lordship I'll just read out another paragraph.
Please narrated the facts.
Lordship.
For that purpose, only the definition of effective steps.
Correct.
Can only be relevant for that purpose.
No, Lordship,
What I'm saying is ultimately they are the file document. But it's not just the way they- anything that the- Actually, the relation, the amount of the matter, after the member, those is not there. The petitioner is not exempted.
Ultimately, what direction the Learned Single Judge has given?
So Lordship, may I take a second to Lordship, take your Lordship to that amendment part, Lordship. That's what amendment will be very important, Lordship.
So just for the sake of it, now what the ultimate direction of the Learned Single Judge?
Learned Single Judge has remanded the matter and
Therefore,
remanded the matter.
On a thorough consideration of the matter in the light of the discussion made above, resolution dated so and so, so and so, so and so is beyond the policy of the scheme. Accordingly, the same is interfered, matter is remanded back to the state of predetermine the contour of central capital investment, which the petitioner is entitled in terms of the policy and the scheme. D holds the resolution number so and so, so and so. Such consideration would be made within a period of 3 months. So even though if that, whatever the definitions which has been changed or applicable at that relevant time, the SLC may decide in accordance with law.
So Lordship,
On the basis of these amended definitions or existing definition, the industry is entitled for the benefit. It's okay, not entitled for benefit. Then fine.
Your Lordship, that has been already done by the SLC in their meeting, stating that certain portion of the plant and machineries will not come under the definition of plant and machineries because those were subsequently installed. So that has been challenged, Lordship. Now, Lordship, the matter has been again remanded back. So as SLC has to take the decision on the basis of, they have to come to a conclusion on the basis of the policy only, Lordship. Now, in the policy and the scheme, Lordship, the definition has been changed. Now,
when it was changed, when this case was decided or considered or later on it was changed?
No, when the case was, Lordship, that amendment came only 3-4 months after the scheme was promulgated. So it was there at the point of time only.
At that point of time, then now the SLC will take into consideration those, whatever the amended definitions, and then has to take a decision.
No, Lordship, that finding is, Lordship, if your Lordship comes to the finding.
The finding ultimately para number 34.
33 also, Lordship, may kindly have a look at the 33, your Lordship. May I read here, Lordship?
Yeah.
Viewed in the above context, the resolution of the state level committee dated 23/9/2011 and 24/9/2011 that plant and machinery purchased and installed after a date of commercial production should not be considered as admissible investment is a deviation from the policy and the scheme. Mandate of the state level committee is to go into details of each case to decide whether the industrial unit qualifies for a grant of subsidy and also about quantum of subsidy. What state level committee has done in this case is that it had laid down some kind of policy as for which purchase and installation of plant and machinery after a date of commercial production would be considered as inadmissible investment. It is not only beyond the policy and the scheme, but also runs counter to the policy and the scheme as discussed above. As discussed, it is not the purchase and installation of the plant and machinery post-date commercial production, which is relevant, but what is relevant is the relatability of investment in plant and machinery to commercial production of the industrial unit. If the indents were placed after 1/4/2007, but before 31/7/2008, the fact that certain plants and machineries were installed post-date of commercial production would be of no consequences.
एक इशू है कितना एंटरटेनमेंट on this scheme, this
Yes.
Lordship,
Mr. Kalita, the learned single judge is asked the SLEC to take a fresh decision as per the policy. There is no direction to decide the matter in a particular manner. Why are you shying away from taking a decision? If you find he is not entitled, he is not entitled.
No, only
Earlier process was found to be not okay.
only Lordship, my concern is only with this the paragraph that Lordship I have.
Which definition as per you, which has a substantial change?
Yes, Lordship.
Yes.
Yes, Lordship.
Just
Lordship, that definition, Lordship will find it page 37 here, Lordship.
37.
37, Lordship. So earlier, Lordship, trust was on effective state in the definition, as a Lordship has seen. Now the trust has been given to date of commercial production. Lordship will find it page 37 here, Lordship.
Yes.
So now, Lordship, that this is an amendment to the earlier scheme. So at 4, Lordship will find definitions. New industrial unit means an industrial unit which commences commercial production on or after 1st day of April 2007, but not later than 31st day of March 2007. An existing industrial unit means an industrial unit which commenced commercial production before 1/4/2007. So this definition also, it was not considered in the judgment in the judgment and order, Lordship.
So what would have happened if this was considered?
Lordship, the effect would be, Lordship, because effective step means, Lordship, as I have read out, that putting a farm order also. Putting a farm order, you become eligible. But here, Lordship, that you will have to go for commercial production. Lordship, commercial production is, Lordship, commercial production means every machinery is at place, they are functioning.
This is what the only amendment in the definition.
That is one thing, Lordship. Another thing, very important thing, which has not been considered by this learned single judge is Lordship definition, like clause number 6 of the policy. I'll just point it out, Lordship, for a second, Lordship. That is at page 32 here also. Page 33, Lordship, and come. Page 33. So here, Lordship, it has been provided which plant and machinery has to be considered. Serial number 6 here also, clause 6.
Yes.
May I read out, Lordship? The number 1, Lordship. In calculating the value of plant and machinery, the cost of industrial plant and machinery as erected at site will be taken into account, which will include the cost of productive equipment such as tools, jigs, dies, molds, instruments, frame, etc. So plant and machinery that you have ordered, which were not brought into the site as yet, and which were not put into use in your commercial production, cannot be considered, It has to be erected. And this aspect of the matter was not considered in the judgment and order, Lordship. I'll just point it out, Lordship. Only a passing mention was made about this clause, but it was not discussed at all. Because it has to be erected. The plant and machinery has to be erected.
Then when was the occasion for them
Lordship.
to have this provision that firm order is to be placed? Where was the occasion for inserting this clause there? If this was the intention of the policy, that only the plants and machinery which are actually placed or erected can only be taken into consideration, then where was the occasion for them to have this provision that firm order of placing that plant and machinery
Yes,
should
Lordship.
also be taken into consideration?
Yes, that is why, Lordship, that amendment has been brought in. That is why, Lordship, that amendment has been brought in.
With this amendment, that provision of this
that has been taken away, Lordship.
Where is that?
That clause 4 has been amended, Lordship. Clause 4, Lordship may kindly come to page 32. Page 32, Lordship. Originally, this was the clause 4, Lordship, definition. Page 32.
New industrial unit and existing industrial unit. Yes.
So here, Lordship, new industrial unit means industrial unit for setting up of which effective steps were not taken prior to 1/4/2007.
Fine.
Then existing industrial unit means the industrial unit for setting up of which effective steps were taken prior to 1/4/2007.
Fine.
Now, Lordship, this has been amended. Amendment, Lordship, as Lordship will find it that I have already shown, Lordship, that page.
This amendment only which commences commercial production on or after but not later than means it commences commercial so and so.
So
okay, fine.
This has been amended in 30 at page 37, Lordship. Now this effective steps has been taken away. So effective step has been defined there.
This effective steps, this definition has not been changed.
Lordship.
This definition of this effective steps, definition E, that has not been amended.
That has not been amended. But effective steps have been taken away from the definition of new industry. That industries first they'll have to qualify. So for qualifying, they'll have to go for commercial production, not effective steps.
Taking away this effective steps. This definition itself is important. It becomes redundant. Deleted in one. Discretionary order of demanding the matter to the it should be better. Like that. Not the I think to prefer example. Latest amendments. Applicable.
So, Lordship, that definition has been changed drastically, Lord.
Mr. Kalita, there is a fundamental question. Please answer that.
Lordship.
All these things, whether he is entitled or not entitled, the learned single judge has only asked the SLEC to examine it and pass a fresh order. Why don't you do it? Whatever is your argument, you put it in black and white after examining the definitions and applicable rules and policy schemes. That's all. This is a discretionary jurisdiction exercise. And a single judge was of the view that the SLSC has not applied the correct parameters while rejecting his application. So it has to be done again. Do it again. What is the problem?
So Lordship may kindly pass an order into the record. The only thing I was concerned with that particular paragraph, Lordship, I have read out. That paragraph, Lordship, actually.
Whatever you are arguing, we have serious doubts about that. Until and unless this effective steps definition is there in this scheme itself, you can't proceed this case since the definition of new industrial unit and existing industrial unit is changed. Therefore, this will the effect of that would be that this definition itself will go. We have
The Lordship, I mean, the object behind, in my humble submission, the object behind changing the definition is that commercial production. The commercial production has to happen. So for commercial happening of commercial production, plant and machinery has to be in place.
Mr. Kalita, all your arguments, just consider this. If the division bench deals with it and gives a finding against you, then the matter is over for the department. Then you will have to pass an order only in his favor. That liberty.
That I understood.
You understood it.
That I appreciate.
We
That I
didn't want to
appreciate.
say that.
Only my concern is only as I have already indicated, Lord. So only that paragraph, Lord. Otherwise, it can be because
that is inbuilt. Don't think so. There is any ambiguity about that.
Dr. Saraf. My learned friend is pointing out about the definition change. Let me tell you why the definition was changed. In this case, there is no dispute that the commercial production started after the specified date. There is no dispute about that. Now, this definition was changed because of the fact that certain people take steps and thereafter, before the expiry of the policy, they don't start the commercial production. And thereby they say that we are covered by the policy, we will have the benefit of the policy. So the definition was changed that you must start the commercial production within the validity of the policy itself. Now, in this case, there is no dispute that I started the commercial production within the during the validity of the period.
That you have started and that is going on.
So there is no dispute. So that definition which my learned friend is saying that effective steps changing and the commercial production, that is not concerned also, and that is not the object also. The object is altogether that you should not say that I have taken effective steps and you don't start the commercial production within 5 years. After the expiry of the policy, you say that I've taken commercial production and I will avail the benefit. Now you're also see what has happened in this case. It must be erected. The machinery must be erected, it says. Why it is said, certain machinery, I may keep it and keep it in go down. Anything which is not related also, I purchase 5 crores of machineries, keep it in go down.
Claiming the benefit of that.
And avail the benefit. So they say that you must erect it. And there is no dispute in this case that the machinery was erected. There is no dispute. What is the dispute? That you have not erected prior to the date of the commencement of commercial production. If my learned friend can say a single word, that all the machineries must be erected before the date of the commercial production, my lord, I will say that I have no case at all. Purpose is that, my lord, what machineries have been installed, the capital investment subsidy is given, that what investment you have made in the new industry unit.
Capital investment.
In this unit. Now, when I start the commercial production, all the machineries, it's not so that everything is installed and the commercial production starts. Because certain machinery like packing machine, this machine,
sometimes occurred later on.
And I place the order before the commencement of the later production, it reaches. There is no dispute that it was installed. There is no dispute that the Indian state payments were made prior to that. Now, the condition is that it must be erected. There is no dispute that it has been erected. How he can say, that the definitions are changed and yes, please sit down.
Yes, sure.
I think you have got a weak case. That's why you are in between disturbing now.
No.
My lord, my purpose is, my lord, submission for lordship is that if your lordship looks into the scheme and the policy of the Northeastern policy and capital subsidy scheme, then you also find the intention is to give subsidy on the total investment made. by way of plant and machinery. Second condition, the machinery must be erected. First, that you must start the commercial production after 1/4/2007. Now, in this case, all the three conditions have been fulfilled. Now, if all the three conditions have been fulfilled, then it cannot be said that because you started commercial production today and tomorrow you install it, so you are not entitled to the capital subsidy. This is not a case of the excise exemption or sales tax exemption.
There may be eventuality with that after installation of commercial production, you need something else also for betterment of the product or something else.
Well, commercial production normally, in spite of the 75% ready, the commercial production starts. The machineries are installed after 10 days, after 15 days. It's not so that I am undertaking a substantial expansion subsequently. That is not the case. In the project report, all the machineries were there. The indents for machinery were placed earlier. Payments were made. They reached after the commercial production, and the commercial production thereafter it was did. Commercial production was.
You're right, Dr. Saraf, but perhaps the anxiety of Mr. Kalita's client is on account of the fact that there have been instances where people have actually done nothing but has faked production just to have. Not saying that it has happened in your case, but there have been instances.
Direct. In case anything, the machines were not installed.
That's
the machines were not there. I will be the last person, to say the subsidy should be given.
But that's why we are asking you examine and pass an order.
The lordship, as far as lordship that machineries were erected and all lordship, as far as their own document lordship, what their document says lordship, only I'll just read out one paragraph lordship. Page 73 lordship for a second lordship. That is their own letter.
Why are you asking the division bench to record a finding on facts?
That's replying to his.
It goes against you. It goes against you, Mr. Kalita.
Only one line, lordship. After that, I'll stop this. Whatever your lordship says. The order for capital investment in plant and machinery were placed well before the commencement of production, except for order for some ancillary parts, which could be placed only after the commercial production had started to suit the need and feature of major plant and machinery. So erection, as far as erection, there is no, not all the machineries were erected, and they have submitted one document whereby the placement of the orders have been given. Anyways, lordship, I will leave it to your lordship. Only my concern was that only one paragraph, lordship, if lordship can take care of that, then we'll decide the matter first.
If your lordship reads this line which my learned friend is reading, your lordship just read the line which my learned friend read. What it says, that except some ancillary parts which will necessary for the installation was placed later. Now machinery comes at the time of installing, something more parts are necessary. If they are placed, can it be said, that the machineries are not? If they say that machinery was not installed, where it is there that machineries were not installed, there is no in the before the learned single judge also there was no stand taken that machinery was not installed. The state level committee rejected only on the ground that the machineries have been installed after the commercial production. So they have admitted that it is installed. So, in my humble submission, the lordship sitting in the read appellate jurisdiction in intercourt appeal, where if unless there is some such a perversity or some illegality is shown in the judgment of the learned, I think this court, under court will not interfere.
Dispute तो खड़ा कर रहे हैं अभी कह रहे कि it was not installed prior to.
We will simply dispose of this writ appeal with the direction that
you see page 211, page just
what we are proposing, without interfering in the order, we'll simply say that as per the order, this order passed by the learned single judge, the state level committee shall consider regarding this.
In terms of the judgment,
In terms of the policy in vogue at that relevant time.
you will ask me just for my satisfaction, page 211.
211.
Para 31.
31.
My lord.
Yeah.
Sought point for consideration is whether the state level committee was justified in not considering the investment made in plant and machinery which were installed after the date of the commercial production.
That is the finding.
So, the state level committee has said that since it was installed after the commercial production, we will not consider it. So there is no question, that the machines were not installed. And you'll also think, you'll see.
No, that was not my case.
At page 210, page 210, the finding of the state level committee,
The finding of the state level committee is recorded by the learned single judge.
At page 210, you'll also
Just the next para.
In the quotation portion,
Para 11.
Para 29,
The state level committee in its 14th meeting so and so adopted a resolution to the effect that the plant and machinery is purchased and installed after the date of commercial production should not be.
The resolution itself is reproduced at page 210. The resolution is there, page 210,
Yeah.
The
commercial.
The resolution in the quoted portion, the committee resolved that the plant and machinery purchased and installed after the date of commercial production should not be considered. So this is the resolution.
So there is no dispute about that the commercial production was already started.
And there is also no dispute that it was installed.
I am not disputing that. What my submission was that at that time of commercial production, those machineries were not there. I have not stated that those were not installed later.
Plant and machinery purchased and installed after the date of commercial production. There is no doubt about that. That the commercial, no dispute that commercial production was already started.
They have started, but certain machinery was installed later on after the commercial later products.
Whatever it may be, you consider it. Whatever the learned as per the learned single judgment, you decide it in accordance with the policy in vogue at the relevant time. That's all.
Because your lordship, what has happened, if lordship peruses page 192, there's a list they have given when those machineries orders were placed. So
neither the learned single judge has taken into consideration, nor we are going to take into consideration. We'll simply say SLC should decide the issue as per the provisions of the policy in vogue at that time.
Lordship, that
is Mr. Saraf.
And in terms of the judgment of this honorable court.
No, naturally, that is there.
Well,
Liquid.
Sir, before you start, we as discussed, it is not the purchase and installation of plant in post state of commercial which is relevant. But what is relevant is the relatability of the investment in plant and commercial production of the investment. If indents were placed after but before 31/7, then there's certain plant and machinery from post state of commercial
This writ appeal is filed by the appellants being agreed with the order dated 25/6/2019 passed by the learned. Passed in WPC number 4649/2013. Would stop. The respondents herein have approached this court with a grievance that the respondent the appellant's state level committee.
Yes, Lordship, state level committee.
It is party here.
State level committee is not a party.
The state level committee of the respondent commercial taxes department. This department's name is commercial taxes department or what?
The industry and commerce.
Industries and Commerce Department has illegally refused to grant certain benefits as per the policy of northeastern region, as per the policy, namely Northeast Industrial and Investment Promotion Policy 2007. Stop. The learned single judge, after taking into consideration, after dealing with the provisions of the policy in detail, has come to the conclusion that the state level committee is not justified in rejecting the claim of the respondents. Full stop. After observing this, the learned single judge has interfered with the resolution taken by the state level committee on 23/9/2011 and 24/9/2011. However, remanded back the matter to the state level committee to redetermine the quantum of central capital investment subsidy to which the petitioner to which the respondent is entitled in terms of the policy and the scheme, in terms of the policy and scheme. Having heard the learned counsel for the parties at length, we are of the view that the learned single judge, that the order passed by the learned single judge is not liable to be interfered with, as the same is being passed after taking into consideration the various clauses of the various relevant clauses of the policy. Full stop. Learned counsel for the state has submitted that certain clauses of the policy which were amended at the relevant time but not taken into consideration by the learned single judge. Full stop. We are of the view that the learned single judge, while remanding the matter, has gave a specific direction to redetermine the case of the respondent in terms of the policy and the scheme, which means that the policy and scheme in policy and the scheme in force at the relevant time. In force at the relevant time. Full stop. Hence, the state level committee is required to redetermine the case of the respondent as per the provisions in terms of the policy and the scheme in vogue at the relevant time. With these observations,
But also in terms of the judgment of the court, my lord. Otherwise, my lord, the judgment of the honorable court says, my lord, that the date of investment, whichever is there.
sir, that is, we are not interfering with the judgments.
My lord, if your lordship already will appear that they will take advantage of it, my lord, that only we will discard the.
Light of the judgment passed by the learned.
And in the light of the judgment passed by the learned single
That
judge.
is highly obliged.
Obliged.
With these observations, this inter-court appeal is disposed of.
Item number 34 to 38.
Oh, sorry. Yes. May it please the lord. My lords, had the occasion to hear the matter on last occasion at some length. Now, issue is there are about 6 appellants in all. 6 appellants who appeared in the combined competitive examination conducted by the Public Service Commission. Now, as far as the 2 appellants, that is Writ Appeal 361 and the other is 354, 364, the 2 appellants appeared in the mains examination as well as viva voce on the strength of the interim order passed by the learned single judge. But they came out successful. They cleared the viva voce also. Now, there is another set of 4 appellants before lordships. They also actually did not qualify in the prelims. Only when subsequently in the main writ petition, when affidavit was filed by the APSC, then it came to light that there were about a batch of 98 students who, according to the APSC, ought not to have passed the prelims, but they appeared in the mains. And out of that 98, 8 candidates eventually qualified for the mains. And out of the 8, 4 cleared the both mains as well as viva voce. These are the 2 sets of people, candidates who are before your lordships.
Now, people here are who failed to qualify the preliminary examination.
Yes, because of the wrong answer key.
But on account of the this intervention of the court, they appeared in the main examination and now they cleared.
Yes. And in fact, my lord, prima facie, we could satisfy the learned single judge, my lord, that the answer keys were wrong. My lord, for example, how many seats are there in Rajya Sabha? 245, everybody knows. My lord, APSC says it is 250. How can that be believed, my lord? Forget about anything else. It's a question which flows from the constitution. And my lord, the stand of the APSC before the learned single judge was, since preliminary is only a screening, and post preliminary there are 2 levels of tests. One is main and the other is viva voce. Therefore, in respect of the 4 who are represented by my learned friend, my lord, the APSC stand was they stand by their selection. And as far as we are concerned, the 2 clients whom we represent, their stand was it was left to the Honorable Court's discretion. They did not oppose it because a specific view was sought by the learned chair. My lord, with great sense of responsibility, I am making one submission, my lord. The ground that there is no provision for relaxation, nobody argued, was nobody's case. The matter was heard in 2019 and the judgment was delivered almost after 2 years in 2021.
21 judgment reserved, 23 after.
Sorry, 21 judgment was reserved and 23 judgment was delivered almost after 22 months. So, my lord, nobody argued that. And my lord, lordship knows if the rules of APSC does not provide for re-evaluation, will that principle, my lord, if there is a wrong, it has to be remedied. If there is a right, that has to be enforced. Will that principle of ubi bis that ubi jas civism will not apply? In fact, I think in one of the judgments, this Honorable Court has applied that principle. That is the case in nutshell, my lord. Now, I may just indicate to your lordship the stand of the APSC before the learned single judge. Then where was the occasion to adjudicate, my lord? Please come to page number 348. I'm referring to the, my lord, the stand which was placed before this Honorable Court.
Stand.
Yes. 290. 290.
So now the petition is in relation to how many candidates?
6.
6.
And by virtue of by interim order, my lord, the posts are not filled up. So in the subsequent advertisement, it has not been filled up.
And all these persons are one set of persons or 2 sets of persons?
2 sets of persons, as I've indicated, my lord.
One who failed to qualify the preliminary examination, but later on, with the intervention of the court, appeared and
yes,
cleared the examination.
And others also essentially the same, but then the APSC cleared them. Subsequently, they found that this 98 ought not to have been cleared.
Vacancies तो है, fill up 6 vacancies are there.
If a lordship may kindly come to page 290, my lord, that was the stand of the APSC before.
But these 6 people, they have also appeared in the Vivavacy.
Yes, mains Vivavacy were selected,
But failed in the prelims.
failed in the prelims because of the wrong answer key. The cutoff. 261 was required. I think the two candidates I represent, one got 258, one got 254.
So there are altogether 5 appeals, right?
Yes.
5 appeals.
Both.
Five.
Five.
Two candidates have filed one appeal. And six candidates are.
Six, in all 6.
You are appearing in which appeal?
I am appearing 361 and 360. Huh?
The learned
360.
single judge has given this finding that the answer key is wrong. Was wrong.
No, the learned single judge said, my lord, and no, learned single judge has not answered that question directly. On the contrary, learned single judge has taken the view. Number one, there is no provision for re-evaluation, therefore you cannot re-evaluate. And secondly, there is no provision for relaxation. Nobody's case, nobody argued that. And we relied upon it.
Relaxation for what? Relaxation, where is the question of relaxation?
There's no question. But then that is an aspect which was addressed by the learned single judge. If a lot of them kindly come to page 290.
And what is the stand of the state?
State, my lord, the state has not objected. State has not objected.
Not objected.
Yes. Even before this honorable court also, state has not.
The state is ready to give you the.
Because APSC itself has taken that stand. That's why I'm saying, my lord, please come to.
But state is ready to.
Yes. State has not. We're already selected, my lord, the posts are kept vacant.
Who has put the state? APSC.
Basically, APSC and my lord, state are the respondents.
Ultimately, appointment has to be given to the APSC.
Yes.
APSC
is on the authority.
APSC to recommend your name.
Yes.
And then what appointment.
State will appoint.
So what is the stand of the state? Where is the state?
They never filed any affidavit, neither they objected our prayer.
Go by the order of the court. APSC stand is they'll go by the order of the court.
No, in 2 stand, in respect of the 4, they stand by the selection. And in respect of the 2 clients whom we represent, left to the discretion of the court. That's what I wanted to show, page 290 for a moment, my lord.
Yes. 290.
Yes. In item, writ appeal 361. Writ appeal 361.
361. Item 35.
Yeah.
They don't have a positive. The positive, they are not included. Yeah, that is why they don't have a concept.
Yes.
Yes. Place page 290, Miller.
Yes.
I'm reading the content part. It was pointed out that the Honorable Guwahati High Court by order dated 22/12/2020, passed in IA number so and so, was pleased to direct Commission to declare the final results of CCE and withheld the results of 6 candidates. Further, the Honorable High Court by order dated 18/1/21, passed in WPC number so and so, directed Commission to clarify its stand with regard to the aforesaid 6 candidates by filing fresh affidavit in this regard on or before 28/1/21. The Commission discussed the matter and observed that out of the 98 candidates, 68 appeared in the CC mains exam, and out of these 68, 4 candidates, so and so, so and so, so and so, would make it to the final select list. And in persons of the order dated 22/12/20 of the Honorable High Court, withheld their recommendation to the government. Commission is now of this important of the considered opinion that as CC preliminary exam is a screening test, and they could not clear it by whisker. And these 4 candidates, by virtue of their own merit, could successfully clear CC main exam and Viva Voce, both of whose marks are seen to be taken into consideration in the final selection. Hence, the Commission may fully stood by their recommendation as justified. With regard to the 2 petitioners in WPC number so and so and so and so, the Commission opined that the Honorable High Court in interim order allowed both the petitioners to appear in the CC main exam, and they cleared both the CC main and Viva Voce by securing position in the final select list by virtue of their own merit. As such, the Commission in respect of these 2 petitioners leave the matter to be decided by the Honorable Court, and hence Commission has nothing to object to any decision taken by the Honorable Court by considering the fact that both the petitioners have qualified for recommendation by Commission on assessment of the respective merit in CC main and interview. So even in respect of us, the APSC's clear stand is they will not object. They are not objecting that. And moreover, my lord, the marks which is secured by candidate in prelims, these are only qualifying in nature. So those are not included in the, or these are not, taken note of for the purpose of final selection.
98 candidates were wrongly allowed to participate.
Yes.
And out of these 98,
68 appeared in mains, and out of that, 4 candidates could make it to the final selection.
68 pursuant to the direction given by this?
No, there was no direction in respect of that.
68 before?
On their own, they continued, my lord. Only later stage when the affidavit was filed, this fact came to light.
so these 4 are out of the 68.
Out of the 68, yes.
And what about the other 2?
other two, whom we represent, my lord.
Yes.
On the strength of the interim order, we appeared in mains and viva voce.
They failed to pass this prelims exam.
So why this, why 98 should not, why 98 were wrongly allowed? What was the wrong about it?
I think, my lord, page 177, they have clarified that position.
On their own, the APSC has revised its answer key and then they.
Actually, my lord, initially when the first answer key was published, then, my lord, I'll just give the figure, my lords. I'll give the date also. Yes. APSC declared the, so initially, my lord, 3361 was declared to have cleared the prelims. Then, my lord, actually the procedure is, first APSC has to upload the answer key, then they are supposed to publish the result. Here they did the opposite. First they declared the result, then they published the answer key. Then a hue and cry was raised in the state, my lord. All the newspaper reported about this anomaly. Then they came up with the second answer key. And in the process, what they did, 406 more candidates were declared to have qualified.
And 98?
98 was within that. Within that, 98 were there. Oh, yes,
No, 98 were outside.
98 were out.
Yes.
468 came in, 98 went out.
468 came in, 98 out. Earlier answer, as per the earlier result, 98 who were selected.
What had happened, my lord, when the first answer key was revised, the second answer key, there were few more candidates who were included. Those were 406 candidates. But the APSC had declared that after revision of the first answer key, there were few candidates who were selected as per the first answer key. They ought not to have been selected.
98.
But 98.
98
They say
numbers
that
of that.
they did not give out the names who were those candidates, but they said it's without prejudice to those 98 candidates, we won't disqualify them. And these 4 candidates were part of the 98 candidates. They never knew, my lords, that they were part of the 98 candidates. They only came to know when we filed the writ petitions, and during the last.
They have not disclosed it.
No,
They
names were not.
said 98%.
No, names were only disclosed in the petition, man, in the writ petition.
In the affidavit.
Affidavit. And that's why we.
You are representing those 4 candidates. You
I
are
appear
representing.
for 2, my learned friend appears for another.
You appear
And
for
I appear for those 2 candidates who on the strength of interim order were allowed to appear in the main examination. But
selected. And selected.
and selected.
All 6 are selected. We discover when the final list was out, our names were not there and 4 votes were withheld. Then there was a noting subject to orders of so and so date. They discovered that actually was pending case and we've got to select it, but the order of the court didn't feel so fill up these votes. Then we filed an intervention. I'm talking about 90. 90 is now the first list that was notified as such. Qualified. Thereafter, the whole confusion happened, and then 406 is without presence.
What did you do? There 3361 or 92 kuma aise. It is. And even second answer key was not free from error. They themselves admit.
The selection is of the year.
Actually, my lord, the advertisement 18. The vacancies of the year 18, but selection took place in 19, started in 19.
19. And the appointments, the selected candidates were given in
2020.
2020.
Yes.
Final selection.
We are just contemplating some order. It's not yet final, but we're trying to adopt an equitable approach.
Exactly.
Since the APSC and state have virtually, they are agreeable to some accommodation to your clients, and there is no serious opposition. Now, if we pass a mandamus to appoint, what about, will you claim seniority amongst the others?
Perhaps not, mine.
No. Are you ready to give that undertaking, that
Based on the date of selection, seniority.
date of appointment?
Date of. Thank you. Do you want to give it? Two of the.
Give me a moment.
2-3%.
What do you mean? Still, you can't
well,
choose
well,
anything.
And
You can't choose anything.
we are just
Still,
being very
this-
equitable.
If
That's
you
all.
open this case, then certainly you will not be able to.
Exactly.
even
I'm
get
very
a-
careful.
That's why I said, my lord, instantly I said.
Yes, ma'am.
In fact, my-
Actually, one, the petitioner actually got through the last one, so he's already joined.
not 1, 2, my lord, even the appellant in item number 34, she cleared the next, she's already appointed in the next year to a lower, she's appointed as an account.
I think so. She will not opt for that. As
She
per
opt-
her adjustment,
But there is
she can't opt because if she'll not get the seniority, there is no question of.
But the batch-wise seniority will be
that will be
maintained.
there.
Batch-wise,
That's why seniority would be there.
not inter se, batch-wise seniority will be maintained.
But that's right.
Yes.
They'll be treated. to
That's
the-
why, yes, yes. Because subsequent to that, there is a recruitment also. That's why we are saying this. That's no interest in the batch, but batch wise, yes.
Because if you are claiming inter-se, then you have to
No,
make
no,
them
no,
party.
We're not claiming.
No.
And what about APSC and state? What is your stand? Sorry?
Yeah.
Page 290, I read, my learned friend is referred to that.
That is your stand?
Yes.
No objection? Proposal nahi hai. In fact, you are not objecting and you have, in fact, recommending 4% they have selected and who ke liye you said the court, if the court gives them. What about state? Huh?
No, we are prepared, my lord.
That's right.
Before the honorable single bench, neither we file any affidavit. What I
Alright, today, what is your stand? Tomorrow, you will again come with the review ke sab humko suna nahi. This happens here any day.
taken up tomorrow, so that senior government advocate.
Yeah, you take your time on Monday. Clarify, Mr. APSC may also clarify your position and you may also clarify.
Why don't both of you file a short affidavit, 2-page affidavit?
Only short affidavit. Again,
No, have you mentioned it? Where is it? Which page? 429. Which is the relevant paragraph? Yes, they've taken a study.
Page number?
Page number
434. 434.
433 Lordship. The deponent stated on a slip of the order showing passed by the honorable court in Dublin, that is number 1172. The commission had meeting dated 19/10/23. Despite the issue raised by the council of the applicant with regard to the entitlement of the equitable relief, 98 other candidates who were shown to be selected in the first entity, who were ousted in the revised entity, so motto issued by the APSC, but they have been allowed to appear in the final examination by the APSC on its own. The commission discussed and took note of the earlier issue and adopted resolve that minus the meeting of the commission.
Yes, that's right. That's enough.
But what about the state?
Malad, they never objected anywhere, Malad, even as a single judge also did not.
Can you file it by?
Chaudhary, for the appendant question, let them file.
Or let them have the instruction on Monday, my lord.
Not 7. Tuesday. Fourth.
They are all election results.
Acha, again, election results. इनका भी result
Let it be
निकाल
on
दो.
Monday, my lord. Monday.
Monday hearing.
They will have the instruction.
Not be. The problem is that it's listed, it would be listed in the hearing.
Parted matter,
Okay,
fixed parted matter.
parted matter,
File a short affidavit.
Monday.
Lordship, may I tell you? Monday, I have also found difficult. I am leaving for Kolkata today, Lordship.
Your junior will be here, that will be fine. We know your stand.
And you please file a short affidavit, only of 2 pages, that's all. Monday. Parted. This for birthday hearing on Monday.
Fixed parted matter. Mr. Das, have you understood what my lord has indicated? File a short affidavit that you stand by the resolution of the APSC and will comply with it.
Yes.
If an order is passed, that's all. Yes.